Faites l'appel, s'il vous plaît, Madame le greffier.
Monsieur le Senator Gorst. Monsieur le Senator Farnham. Madame le Senator Ferguson. Monsieur le Senator Lafondre.
Présent.
Madame le Senator Valois.
Présente.
Madame le Senator Moore.
Présente.
Monsieur le Senator Pallet. Monsieur le Senator Mezek.
Présent.
Monsieur le Connétable de Saint-Hélier. Madame le Connétable de Saint-Laurent.
Présente.
Madame le Connétable de Saint-Sauveur. Monsieur le Connétable de Saint-Brelard.
Présent.
Monsieur le Connétable de Grouville.
Présent.
Monsieur le Connétable de la Trinité.
Présent.
Monsieur le Connétable de Saint-Pierre. Monsieur le Connétable
Présent.
de pardon. Monsieur le Connétable de Sainte-Marie.
Présent.
Monsieur le Connétable de Saint-Ouen.
Présent.
Madame le Connétable de Saint-Martin.
Présente.
Monsieur le Connétable de Saint-Jean. Monsieur le Connétable de Saint-Clément. Madame le Député Martin.
Présent.
Monsieur le Député Southern. Madame le Député de Grouville.
Présente.
Monsieur le Député Lewis.
Présent.
Monsieur le Député Tadier. Monsieur le Député Higgins.
Présent.
Monsieur le Député Masson.
Présent.
Madame le Député Pinel.
Présente.
Monsieur le Député de Saint-Martin. Monsieur le Député de Saint-Ouen.
Présent.
Madame le Député Dublé. Monsieur le Député Labbé. Monsieur le Député Wickenden. Monsieur le Député de Sainte-Marie.
Présent.
Monsieur le Député Truscott.
Présent.
Monsieur le Député Young.
Présent.
Monsieur le Député Ash.
Présent.
Monsieur le Député Morel.
Présent.
Monsieur le Député Guida.
Présent.
Monsieur le Député de Saint-Pierre.
Présent.
Monsieur le Député de la Trinité. Monsieur le Député de Saint-Jean.
Présent.
Madame le Député Lehegara.
Présente.
Monsieur le Député Ayer.
Présent.
Madame le Député Pershaw. Monsieur le Député Ward.
Présent.
Madame le Député Alves.
Présente.
Monsieur le Député Pamplin.
Présent.
Madame le Député Gardner.
Présente.
Monsieur le doyen.
Notre aide soit au nom de Dieu qui a fait les cieux et la terre. Amen. Seigneur Dieu, Père éternel et tout-puissant, qui a établi le gouvernement et la puissance de la terre pour le règlement et pour la conduite du peuple, et qui nous a commandé d'avoir toujours pour but la gloire de ton saint nom. Nous te prions qu'il te plaise de donner à cette assemblée le don de conseil et de prudence, d'unir les cœurs et les affections de tous ceux qui la composent, de les conduire tellement toi-même par ton Saint-Esprit, que toute leur délibération est accompagnée de ta bénédiction. Réussisse au bien-être et au soulagement du peuple, qu'il te plût de commettre à leurs soins. Car nous t'en prions au nom et par le mérite de ton Fils bien-aimé Jésus-Christ, notre Seigneur, qui nous a enseigné de t'invoquer en disant: Notre Père, qui es aux cieux, ton nom soit sanctifié, ton règne vienne, ta volonté soit faite sur la terre comme au ciel. Donne-nous aujourd'hui notre pain quotidien, et nous pardonne nos offenses, comme nous pardonnons à ceux qui nous ont offensés. Et ne nous envoie pas en tentation, mais délivre-nous du mal. Car à toi le règne, la puissance et la gloire, au siècle des siècles. Amen.
Monsieur le Senator Gorst.
Senator Gorst is at the COP conference today, and I owe something of an apology for yesterday because for at least half the day he was travelling out the island to that conference, and in the morning he was dealing with a certain fishing crisis, which I'm sure we're all well aware of, and was unable to be present in the chamber.
Are members content that the Senator be marked away on state's business? Thank you.
Monsieur le Senator Farnham,
Présent.
Madame le Senator Ferguson,
Defo.
Monsieur le Senator Pallett. Vous jurez que Monsieur le Senator Pallett est tellement indisposé qu'il ne peut pas assister aux États sans exposer sa santé. Monsieur le Connétable de Saint-Jean.
Ah, yes. For the same reason he was excused yesterday, I'll mark him excusé.
Monsieur le Connétable de Saint-Clément.
Malade.
Vous jurez que Monsieur le Connétable de Saint-Clément est tellement indisposé qu'il ne peut pas assister aux États sans exposer sa santé. Monsieur le Député Southern. Monsieur le Député Tadier.
Présent.
Madame le Député Dublé.
Malade.
Vous jurez que Madame le Député Dublé est tellement indisposée qu'elle ne peut pas assister aux États sans exposer sa santé. Monsieur le Député Labbé.
Présent.
Monsieur le Député Wickenden.
Présent.
Monsieur le Député de la Trinité.
Présent.
Madame le Député Pershaw.
Malade.
Vous jurez que Madame le Député Pershaw est tellement indisposée qu'elle ne peut pas assister aux États sans exposer sa santé. L'Assemblée était non, Monsieur le Président.
Les États sont constitués. I'll come to you in a minute, if I may, Senator Farnham. I first want to say something about written answers to questions. Standing orders provide for a written reply to questions. Members asking a question, usually of a minister, must comply with a deadline to submit those questions. And Standing Order 12 provides that respondents are asked to provide their replies by noon, usually on a Monday. In practice, this deadline may be extended to 5 p.m. by the greffier, and the greffier will distribute electronically and in paper form a reply to questions to be tabled at a meeting of the Assembly. Failure to respond in good time to questions that are properly asked puts the questioner, usually a backbencher, at a disadvantage. Members will prepare for a meeting of the Assembly, sometimes for debates, sometimes for oral questions without notice, by reference to the answers that they have been given, that they've received to written questions. It is important that ministers comply with these deadlines, and even more important, now the Assembly is meeting on a 3-week cycle. It is inexcusable that at least 3 members, Deputy Ward, Senator Mezek and Deputy Gardner, did not receive replies to questions by 5 p.m. on the day before the sitting of the Assembly. Indeed, in respect of 2 of Deputy Ward's questions, there had still been no reply by the time the Assembly met yesterday morning. Furthermore, there was no explanation or reason given at the time when the deadline passed in any of the cases as to why the relevant minister had failed to meet that deadline. Such a failure is discourteous to the members who ask questions and to the Assembly. Ministers must ensure that they and their senior staff give sufficient priority to these questions so that they are responded to within the deadline. It is not in the interests of good government or proper scrutiny of the executive for the executive to fail to respond to deadlines that they've agreed to pursuant to standing orders. The second announcement I have to make is that the bailiff has today received a letter from the greffier of the States indicating his intention to resign from his post. The bailiff has agreed that the greffier can stay in post until next summer to assist with transition. Arrangements to recruit a new greffier will be announced in due course. And there will be another time when we can properly reflect upon and mark the greffier's contribution to the life of this assembly. Yes, Senator Farnham.
Thank you, sir. And on the subject of questions, sir, I just wanted to ask for your ruling, sir, on something. In oral questions yesterday, Senator Moore asked a supplementary question which alleged that members of the public or members of the hospital project team were overheard in conversation, sir, and quoted what was allegedly said. I understand, sir, that might be in breach of standing orders, and I refer to Standing Order 10, subparagraph 7, sir. I wonder if you might rule on that. Thank you.
Well, I think from my recollection, Senator Moore, you were asking the Minister about the accuracy of a conversation overheard between two unnamed officers. I think that's right. Is that correct? And I think that technically that is a breach of Standing Order 10.7, which says a question shall not ask whether any statement in the media or made by any individual who is not a member of the state is accurate. But I do not propose to suggest that the record be amended as no persons were identified in the question that you asked.
Thank you, sir. The purpose of reiterating that conversation was not a question of the accuracy of said conversation, but actually to portray to states members the attitude that we are dealing with, particularly in relation to the attitude to scrutiny, sir.
We now return to the...
Sir?
Yes, Deputy Ward and Deputy
Thank you,
Lewis.
sir. Can I just point out the written answer to question 428? I wonder whether that should be in the public domain in terms of the response to that, the fact that the answer was inadequate and needs to be redrafted. It's just because in terms of the public domain of the outcomes of these decisions, it was the email that we received today. Thank you, sir.
Yes, I'm just going to see if I've got 428 in front of me, because I did print it out last night.
I have the text of the email, if that helps.
No, I have it here. Yes, so that it's in the public domain, I was asked to rule overnight on whether certain answers given by ministers were compliant with standing orders in terms of being a relevant response to the question posed. And I ruled in relation to the answer to written question 428 that it did not comply with standing orders as set out in a communication to members. It's merely an extract from some conditions of carriage and didn't appear to be really directed to the question at all. And I directed the Minister to provide a proper reply by 9:30 a.m. tomorrow. Yes, Deputy Lewis.
Yes, thank you, sir. It's a reference written question, sir. Two questions did go missing, for which I apologise to the Deputy and to the Assembly. We got the first question, but not the second and third. I was as surprised as the Assembly when it was discovered, so I had no knowledge of it whatsoever, the two questions. But measures have been put in place to see that it does not happen again. And as I say, I apologise to the Assembly, and the questions have now been answered, sir. Thank you.
Well, if one of them was answered in terms which requires the answer to be reconsidered.
Sorry, beg your pardon, sir. Was that the numbers and ages question?
No, it's 428. I'm not going to read out the question, but it's the answer to written question 428, which you'll need to address again within the deadline permitted by standing orders. We now return to the... Oh, forgive me. Deputy Taddy, a point of order.
Yeah, thank you. So it follows on from the rulings on written questions. So when I submitted my question about social security contributions, it was to ask for figures about the financial impact that changes would have, and they weren't supplied, sir. And I'd like to know your ruling, because even though in broad terms the answer did address the question, it didn't provide me with the information I was seeking, and I don't know how I would have phrased the question any differently to try and solicit the information. And based on what you said earlier, sir, that effectively puts me at a disadvantage in the sense I haven't got the figures that I wanted to have a look at and analyse to decide whether or not to take a further step. And so I'm effectively delayed in any potential action that I want to take on that, sir.
Which answers were these? Because I've already ruled that in relation to two answers that concerned you, they were tabled last Monday, so for the time for querying those has elapsed. But are there other?
Oh, thank you. No, I didn't know whether the time had elapsed.
Yes, it's in my email to all members, including you. I sent
Sorry,
this morning. You may not have seen it yet.
Okay. Thank you. So I'll follow that up offline then in that case.
Thank you. Yes, so we return to the debate on the amendment to the proposition. The next member I had down to speak was the Deputy of St Martin.
Thank you, sir. And I hadn't, as the cliche goes, I hadn't intended to speak in this debate because I didn't think there was anything particularly contentious here. I was going to support the proposition. I didn't think the amendment did much to help, but I could see the importance of getting information, and I thought it was all fairly straightforward. And then the issue of legal advice came up. The importance of any party taking legal advice in confidence. And as I listened to that, I found myself asking the question, how would I feel? Previously, I have been in a position where I've needed legal advice and taken it. Always worked on the basis, as the Attorney General says, that you take it, you don't disclose that you've had it, you certainly don't disclose the advice you've had. And I felt that was really important because people across this Assembly, wherever they sit, are entitled to legal advice, and I think that's the premise that we all work under. And I found myself sort of starting to sway towards not only the amendment, but maybe, going even further than that. But then I sat down and actually looked at it and listened to Senator Valois late yesterday afternoon, who made absolute complete sense. On two counts, the first one, of course, I hadn't appreciated, is that scrutiny panels and PAC, for example, receive all the minutes.
Just want a little bit of attention. Now he does. He wants a little bit of attention.
Sorry, is that someone who ought to mute themselves who's joined us remotely? I don't know who that was.
Unless I've become a ventriloquist very quickly.
Well,
very good one. Absolutely.
Yes, very good one. Do you want to carry on? I think.
Yes, okay, thank you, sir. I've almost lost my train of thought. But Senator Valois made 2 points, and the first one is that scrutiny doesn't want to be confrontational. Scrutiny wants to be a critical friend. Scrutiny wants to help to make things better, and certainly that's the way I've always worked in scrutiny. Get together with the Minister and see whether you can't make the Minister's propositions work better for the betterment of everybody. And then, of course, the other one, sir, is that, as I was about to say, was that scrutiny panels receive unredacted minutes. PAC received unredacted minutes, but at no point do any of those minutes ever contain any of the legal advice. So the precedent is there already. And actually, when you get back down to the brass tacks of it, this is actually, as I thought right at the beginning, this is actually quite straightforward. There's no reason why scrutiny shouldn't receive unredacted minutes. Those unredacted minutes won't contain the legal advice. They don't at the moment, and they won't in the future. And on that basis, sir, I'd ask members to reflect on those points. And I'm going to support the proposition on this one. I think it's important on this matter that we see exactly what's going on. And we don't necessarily, we don't expect to see the legal advice because it's not provided.
Yes. Does any other member wish to speak on the yes. Well, Deputy I saw your light first. Deputy I.
Thank you, sir. It was suggested yesterday that we should amend the proposition overnight to make it clear that the Corporate Service Scrutiny Panel does not call for the sharing of legal advice. As members know, last-minute amendments on the hoof do not generally happen in this Assembly. However, it is our view that an amendment is not necessary in any event. As Senator Valois said in her speech, the intention of the proposition is clear, and the information would be shared as per the Code of Practice, as agreed in P56/2018, which was adopted by the previous Assembly on the 10th of April of that year. Paragraph 36 of the Code of Practice proposition is very clear on this point. It states, "It is recognised by the states and the law officers that the process of seeking and taking legal advice from the law officers is confidential." There is already precedent for unredacted minutes, which do not contain legal advice, to be circulated to scrutiny panels. Both PAC and Economic Affair panels have received such minutes. Also, as this is a proposition and not legislation, the meaning of the proposition will be clear by looking at the Code of Practice and at Hansard, and therefore the language of the proposition is acceptable in these circumstances. It was never the intention of the panel to receive legal advice as a result of the main proposition. We had assumed that the Code of Practice would be in play. At no time did the Attorney General raise concerns with us about the proposition and any need for an amendment. The amendment restricts the ability of a scrutiny panel to see minutes, which, given that other panels have received minutes during this term of office, suggests that the bringer of the amendment is acting to discriminate against the panel. We hope that the Assembly will reject this amendment and support the openness and transparency that is at the heart of the main proposition, the aim of which is to support the effective work of scrutiny in holding government to account. Thank you, sir.
Thank you. Deputy Ward.
Thank you, sir. Well, I'm very pleased to follow Deputy I. He's covered most of the technical points I was going to raise. I asked questions yesterday because I see my interpretation is exactly that as voiced there and in the email to members that we received this morning to clarify. We do receive minutes from meetings. We receive Council of Ministers minutes without legal advice. Couldn't think of the word then, sorry. Legal advice. And the situation regards whether we receive legal advice is in the Code of Conduct. So I think the thing that worries me most about the amendment here is it seems to have, it's like a generic but gentle but ever sort of pervading lack of trust in scrutiny at the moment, which is unfair. Not only is it unfair, but it's actually dangerous for our governance. What scrutiny has done is try to hold a government to account, and that is not easy to do. Scrutiny is not resourced as well as government. It's very difficult to get members of panels because everyone is so busy. I think scrutiny members work incredibly hard, and I'm quite happy to stand up in this assembly and say to ministers, I believe I work incredibly hard as a chair of a scrutiny panel and put in the hours. And I'm willing to have my workload and my day absolutely scrutinised as to what I'm doing. And I think so many members of scrutiny do exactly the same, particularly if you're the chair of a scrutiny panel. And so it concerns me that this amendment seems to chip away at that trust and what we're doing in scrutiny. And I'm concerned about the future. And I'd like to reiterate some points that were made by Deputy Morell yesterday. I don't always agree with Deputy Morell, but I think he spoke very well yesterday when he made some really key points about the future of scrutiny and the future of what we're going to do in future assemblies. I came into this assembly as a party member, and I believe in party politics. I've been wrongly suggested regards not taking scrutiny or using scrutiny. So those sorts of suggestions are simply there to undermine the accountability regime that scrutiny has. And we need to get right in this assembly
the triumvirate, if you like, of scrutiny, government, and oppositions that will come from party membership. Those three things exist in parliaments around the world. And one of the key points to that is giving scrutiny the access to information and the quality of information that it needs so it can do its job, so it can track the development of ideas, it can track the development of policy to see where it fits in. And so I point to a scrutiny panel hearing with the Home Affairs Minister the other day, where he was courteous enough at the end to say, I'd like to thank Scrutiny for the work they've done on the government plan because it's raised issues that we hadn't seen. And so I was very pleased to say, and the Deputy and I are very different politically, but within that scrutiny process, I'm pleased to say that we could hold our head up and say, we've done good work to try and look at the government plan and uncover points from a different viewpoint. And within that scrutiny panel is indeed different voices. And that's the process that we need to understand here. And I think if we all understand, and I'm sure that we do, but put that right at the forefront of what we're talking about today, we can understand why we need to give access to these types of minutes without a fear that, one, they will be misused, two, that confidentiality will be broken, and three, sir, which has been spelled out very well by Deputy Ayer, that there is actually a protocol, if you like, in place that will ensure that those things don't go wrong. Now, I would say to you, sir, that in the future, any attempt, and by any grouping, any party, to undermine that has to be resisted. But, and we all need to remember this, particularly those who have the reins of power, if you want to stop criticism or accountability, you are in a very, very dangerous position. And you will not provide good governance because you will end up in an echo chamber of your own views only. You may not like to hear what is being said, but you have to listen. And so part of that, and I come back to this again, and I'll finish with this, is releasing information that's appropriate. And this particular context around stack minutes, for example, is so crucial for this island over the last year and a half and what we've been through, to give confidence in our population that the decision-making process has been appropriate, to get the population on side, because we may well need that again as we go through this pandemic. So, sir, I see this amendment as unnecessary to the main proposition. The main proposition is a positive step forward, and I really hope that people can put aside their partisan thoughts and look at this and say, yes, actually, this is a really good step move for this Assembly. It will open up accountability, it will open up governance and transparency, and that is desperately what we need at the moment to convince the people of this island that we can value what we do in this Assembly. So I urge members to reject the amendment and go for the main proposition because it's a positive thing to do. Thank you, sir.
Thank you. There's a point of order from the Chief Minister. Chief Minister.
Yes, thank you, sir. It's in relation to the Deputy St Martin, who asserted that the minutes did not contain legal advice. I can confirm the Attorney General and other law officers have spoken and provided advice to the two competent authority ministers, and therefore the minutes will contain a record of that advice, sir. I can't see go to what level of detail that will be, and therefore I would suggest that the deputies inadvertently misled the Assembly, sir.
Sir, may I raise a point of order on the comments?
I'm not sure that was a point of order.
Well, he made an assertion that the minutes did not contain legal advice, and therefore, and what I'm saying, sir, is that maybe it's a point of clarification, sir. I'm saying that that is not factually correct.
Well, the minutes aren't in front of the Assembly, and they can't be in front of the Assembly. But you've made your point. Thank you, Chief Minister.
Thanks.
Senator Moore, do you have a point of order?
Well, yes, sir. I believe that the Chief Minister has just. I'd like to clarify the point that he has made, and the point that the Deputy of St Martin made very clearly, as did Deputy Ayer, is that the precedent that has been set is that unredacted minutes are being shared with scrutiny panels that do not contain legal advice. The legal advice is removed under the Code of Practice, sir. So it was most
Yes,
unfair.
but this isn't a point of order either, I don't think, but I follow what you say. Deputy Martin, you were going to make a speech anyway. Is this a speech or a point of order?
No, it's a speech, sir.
Well, thank you.
And if the Chief Minister hadn't put it in, I was going to say it's very similar to what he's going to say, sir, but we are where we are. Yeah, so I listened very clearly every time the Attorney General spoke yesterday, and I think a lot of other people should have done as well. The Attorney General will not get political, but the Attorney General said he's read through 41 sittings of the competent authority minutes, and they're not separate because he's giving legal advice. Imagine we were shutting pubs down, we were shutting hairdressers down, and they'd, what come back on this? So the legal advice will be in the text, sir. And the Attorney General said, and how do I square this circle of not being redacted? And it doesn't matter about the code. The code was put to the Attorney General 3 times, twice by Deputy Warden, once by Senator Wolvo. And then she stood up and said, oh, it'll work because we've got the code. You don't have to release the advice. No, he doesn't, but he will have to redact it. It says quite clearly unredacted minutes. It can't get no clearer than that. If it had been written on a separate sheet of paper after, like sometimes, I've been at PAC and I don't remember getting much legal advice. I was on it for 3.5 years. This is different. It was something that was never been done in Jersey. We were telling people to shut their businesses, go home. How long, civil liberties we were taking away. And we needed legal advice on that all the time. And it wasn't written on the side, it's a B in the minutes, and that's the action. So I don't know how you get around it. Whatever the code is, you can't square the circle that literally their proposition as unamended says without redaction. As clear as the day, and it's exactly what the Attorney General said yesterday. If he is ordered by the Assembly in the wording, he will have to give over the minutes unredacted with all his advice in it. And then I come on to the propositions, sir. Oh, we're on the amendment. Well, when we go back, but it is what they want to do with it. It's never going to go public. They're going to have to write a thing that would, they want to have a good overview of what was going on in the rooms with the ministers, what the decisions were made, but it will not be, there must be a way that we can get it to the public, but without using that information. But then comes a real howler and a public interest test. It comes back here. We want to give it out. And again, it's still got the legal advice in it. And legal advice is only that. All legal advice can be challenged by another solicitor. And that's what we're going to put our Attorney General in. Because we'll have to release an unredacted, Senator Moore is shaking her head at me, sir, it's unredacted legal advice that's in the minutes. Very much legal advice. The Attorney General said he had read through them all, and he would be very, very uncomfortable if that was put out there. So it's just one word. I don't know if they take it away and they say you can redact legal advice, that might work. You can't do it today. But I've got to vote for the amendment because our legal advice, and you might be minister, whoever's ministers next time, you've got the privilege of council ministers and CAM, we'll be going on, of having good legal advice given really directly, really knowledgeably, in confidence. But as I say, legal advice, once it's out there, can be challenged by another legal person. And we don't want that. So I think, it's not as simple as now standing up. I've had an epiphany overnight. We had an email overnight. It doesn't say it. What is on the tin is what is in the proposition, and what the Attorney General said, he would be put in a very, very awkward position. And you kept trying to ask the question in different ways, and he kept saying the same answer. He doesn't want his legal advice out there. This proposition says we can't redact it, sir. Circle will not be squared. Thank you.
Sir, may I ask you to offer some clarity to members on this point? Because
yes, I think I need to give a ruling on my interpretation of the effect of the proposition. Yesterday, I was asked to give a view, and I indicated that to some extent my view of the meaning of the meaning of the proposition would depend upon a declaration on the part of the proposer as to what was sought. And we've now had that declaration from Deputy Ayer this morning, and of course we saw the email communication from Senator Moore last night to the effect that there is no intention on the part of those proposing this proposition to conflict with the code of practice for engagement between scrutiny panels and the Public Accounts Committee and the Executive, lodged in February 2018 by the Chairman's Committee, which in clear terms at paragraph 36 recognised by the states and the law officers that the process of seeking and taking legal advice from the law officers is confidential. I've had the opportunity to read that code of practice overnight, which I'm sure other members have also had the chance to do. And my ruling now is that the proposition must be read alongside the 2018 code of practice. It does not conflict with it, and there would need to be clear words in a proposition to oust or set aside the constitutional convention regarding advice from law officers regarding which the attorney spoke yesterday. Accordingly, my ruling is that the proposition, when it speaks of receiving unredacted minutes, does not extend to the provision of legal advice from the law officers.
So, may I ask a question of yourself just to understand a bit further about the ruling?
Yes.
What it is the it kind of covers a little bit what both myself somewhat less eloquently and Deputy Russell Abbey very eloquently expressed last night, is does that redaction then extend to discussions over the legal advice that has been granted to ministers, sir?
Well, that's rather a technical question about the extent of legal privilege.
That's the problem, sir.
Well, I don't think that I can really get into that. Obviously, if minutes speak to the legal advice that's being given and recites the legal advice, then that material is privileged. If the minutes recite that certain things were done on legal advice, then those things that were done are not covered by privilege, and those minutes must be disclosed if the proposition is adopted. I don't think I can go into the detail of the effect of the ruling I've given, because the minutes will need to be looked at, if they do refer to legal advice, carefully before they're disclosed. But that's the ruling that I...
Apologies. Normally, so the ruling, the code also says that it should not be referred to in the public domain that legal advice has been sought, for example.
Yes, well, I've just ruled that it's accepted by the proposer, and my ruling is that the proposition, if adopted, will be read alongside the 2018 Code of Practice and is not intended to disapply or make inroads to it.
Okay, thank you, sir. Thank you.
Deputy Martin.
No, I just wanted a clarification to be quite clear. So what you're saying is if the minutes are released, because of the code, the legal advice will be redacted?
Yes.
Thank you.
Councillor Wilson-One.
Thank you, sir. Your ruling has covered the points that I wanted to make, so I don't need to speak.
Thank you. Senator Farnham.
So can I just... Sorry, sir, it's Deputy Tadia.
Oh, yes, sorry, I overlooked your question to the attorney.
If it's okay at this juncture. So the question to the Attorney General would be, to clarify that, first of all, when we talk about legal advice being privileged, are we talking about that being an absolute exemption from it being disclosed, or a qualified exemption? And to give it context, the attorney will know that there are some high-level precedents in Commonwealth parliaments, and one thinks of the Lord Goldsmith advice that was given on the Iraq War, which had to be disclosed in 2003, to Chilcot, to the Chilcot inquiry, about what that legal advice was. And if, for example, it wasn't the scrutiny panel who was asking for, let's say, the legal advice, but in fact the minutes, but it could also be the legal advice to be given to them. It's not to be published publicly, I would add. If there was an FOI request, is it correct that there would need to, there's a presumption against giving legal advice out, but that's a qualified exemption rather than an absolute one? And because it's qualified, a public interest test would have to be applied. And if so, where would the public interest test be applied in that, and by whom?
Mr. Attorney, do you want to deal with that? Or do you want to reflect upon that? You might want to look, well, it's for you.
So I'm not sure how relevant that question is to the practicalities of this particular case. I think it's pretty clear the position's been established that the legal advice is to be redacted. The legal advice in question is law officer advice, and as I said to Deputy Tadier yesterday, that requires both the Minister and the law officer to agree to waive any privilege in that advice. So the privilege is absolute, in that it requires both.
Oh, sorry, sir, I thought the attorney had finished.
No, he's still speaking.
So the legal advice is absolute. The privilege in that advice is absolute. The code itself, and this is the problem that we have been grappling with, the code itself permits the disclosure of legal advice in exceptional circumstances. And that is the problem that we have been grappling with. And that is the ambiguity in the code, in that it both says that it agrees that legal advice, law officer advice, is confidential and privileged, but it also goes on to provide that it can be disclosed in exceptional circumstances. And so something like the advice concerning, Lord Goldsmith's advice concerning the Iraq War would probably be one of those exceptional circumstances. But we are not, as I made absolutely clear yesterday, this, in my view, is not one of those exceptional circumstances. So paragraph 39 is not a basis for support for this proposition as amended, for saying that it doesn't mean that legal advice is to be disclosed, because paragraph 39 expressly allows for the disclosure of legal advice in certain circumstances. So going back to Deputy Tadier's question, the privilege is not absolute in that it can be waived in exceptional circumstances. But in this particular case, we are not in that category of exceptional circumstances. I think that's as far as I can take the answer to the Deputy.
Thank you. So if I could just follow up quickly, the reason I think it is a relevant question in this context is that, from what I understand, I did work on the FOI law when I was on PBC back in the early days, 2009-ish. And from memory, when putting a Freedom of Information request in as a member of the public, legal advice is qualified exempt. It's not absolute. And my concern or my question would be, if a member of the public were to submit exactly the same request that the scrutiny panel are putting in, I wouldn't want to think that they would have a greater access to that information, because somebody would have to make a judgment call about where the public interest lies in the disclosure of the minutes, including the legal advice, versus that information not being disclosed. Whereas in this case, we're being told that actually there can be no wiggle room given to the scrutiny panel. So it just seems to me, and that's the question to the Attorney General, whether somebody putting the same request in under FOI would have a better chance of securing the information that the scrutiny panel is seeking than the presumably sovereign states body, Assembly, putting that same request in.
Yes, Mr. Attorney.
So I confirm that a member of the public submitting a Freedom of Information request which asks for copies of the minutes unredacted, which would include the legal advice recorded in those minutes, would not be entitled to receive the unredacted copy of the minutes, which includes the legal advice, because the legal advice is privileged and it is exempt under the Freedom of Information Law.
So I know it's exempt. Is it qualified exempt or absolute exempt?
Well, I think the Attorney would need to look at the law and come back to you on that, unless you want to do that now.
Sir, can I just say something that may help the Attorney General when he goes to look at it? I can remember being on the same panel and reviewing this. In fact, I brought or asked for the panel to bring over people from the UK. We got expert advice on it. And although the Attorney General at the time, former bailiff, wanted to have an absolute exemption, the panel decided no, it could only be a qualified exemption, in the sense that it had to go through a public interest test. Yes, the public interest test may be very high, but it did not mean that the information could never be revealed. And I think the point here is that any member of the public who had their FOI rejected would be able to go to the court and argue that it was in the public interest for the information to be given. And then it would be decided at that point. But it is not an absolute exemption. Thank you, sir.
Thank you. Does any other member speak on the amendment? No other member wishes to speak. Oh yes, Senator Farmer, sorry.
Thank you, sir. I mean, your ruling, sir, and following advice from the AG has pretty much covered the points I was going to make. I just want to be clear, though, that I was going to raise the issue about the code, paragraph 39, which allows for the disclosure of legal advice in exceptional circumstances, and that might not apply to this instance. The Attorney, the Attorney General, is he saying, sir, that none of the circumstances around competent authority ministers' work throughout the pandemic past and future would be considered as exceptional?
Is that a question for the Attorney, is it?
Yes, it is, sir.
Yes.
So I can't bind myself as regards the future, but I've looked at all the minutes from the previous advice, and I am satisfied that they do not fall into the category of exceptional circumstances.
Though, sir, just in concluding my short contribution, I think, sir, this is possibly for the Chief Minister to decide upon, but perhaps the ruling and the advice from the AG would almost satisfy what the amendment is seeking to achieve. So, and I would also like to impress upon the Assembly that openness and transparency is and has never been an issue for competent authority ministers. All of us in our deliberations and our work, whether it be scrutiny or the government committees, subcommittees, groups, working groups, do require productive and in some cases safe spaces to work in, sir. And simply we are seeking to protect the confidentiality that government and scrutiny need on certain occasions. But I would, sir, reiterate that openness and transparency is not the issue here in any way, shape or form, sir. And I'll let the Chief Minister comment, sir. He'll obviously take a view on this when he responds, when he sums up on the amendment. Thank you.
Thank you. If no other member wishes to speak on the amendment, I invite the Chief Minister to reply.
Yes, sir. I think what I will do, sir, is make a few words, and then I'll then seek some advice, sir, given what's been said. We were very clear in our discussions that we did not want to be put in the position, for all the reasons that have been elaborated on the last 24 hours, that put council ministers in, if you like, in direct conflict between the decision of the Assembly, because of what we viewed or how we viewed the exact wording of the proposition, and obviously any decision made by the Assembly we will abide by. But then the issues around, for example, a provision of legal advice, because it is incorporated in the minutes, and secondly, the comment about a safe space. Members will be delighted to know that on the basis of your ruling just now, sir, I'm going to certainly curtail a lot of my speech. What I will say, sir, there's three things. Number one, in relation to some comments made by, I think it was Deputy Morrell yesterday, when he said that we did not as an island have any secrets, that there was no need for secrets in this way, that the idea of a safe space made his skin crawl, and stated if you need a safe space as a politician, you should not be a politician. I think I do need to address that, sir, because unfortunately it, in my experience, is not correct. We do deal with confidential matters that impact on the long-term future of the island. So, for example, sir, should we publish, for example, and I'll get to the reason why we talk about publishing, all of our internal discussions and comments about the negotiations around the development of the TCA, and, for example, right now about fishing, do we play that hand in public? And I would have to say no one in their right mind negotiates with all of their cards open to the other side, and I'm talking about the other side being off island. Ministers do therefore need the ability to discuss matters freely and without fear of a safe space, and anybody who thinks otherwise, frankly, is me. The GREF prepared minutes are not an outline sketch. I will reiterate the point that my concern is that is what they'll become, not necessarily under us, but under future council ministers, depending where this goes in terms of how bodies act in the future. I do have to also make the point, sir, and I accept fully that in the past there have been leaks from the executive side, it's not a question, but there have also been leaks from the scrutiny side. Within the last year, sir, a scrutiny officer deliberately released information. I understand the exact reasons why, but that was what happened. And sir, a panel inadvertently disclosed the full set of slides that were given to them on a confidential basis on their website. So I think we need to be very clear that this, the confidentiality of that safe space needs to be respected, and that will go onto all sides. And I think what I will say, sir, as well, is that I will quote the Attorney General, who was obviously very uncomfortable last night. I think he's looking a lot more comfortable this morning, sir, I would suggest. But what he said is that when asked, he would be constantly thinking, well, in the future, how would this advice, as it is recorded in the minutes, look to some third party who the advice is not given to, who does not understand the context of the advice? How would that look, and how would it look if it was published to the world at large, who will also not be in the same position as the person who's asked the advice in that particular situation? And to quote, it would put me in a more difficult position. And he also referred to the fact that advice is given on sensitive issues, and it is very important that that advice is frank and does not flinch from expressing the consequences of certain actions that may follow if that advice is not agreed or if it is agreed. And that's the whole point of the problem. That's what we have been grappling with, sir. It is not about not wanting to be transparent. It's how the presentation of information can change depending on how the giver of that information perceives it could be used in the future. And, sir, that would not just apply to the legal advice,
that could apply to all the advice presented to ministers. And that was why, sir, in consideration, we brought the amendment to try to achieve much of what the Corporate Services Scrutiny Panel seemed to be seeking, without the very difficult position I still believe it will create and the unintended consequences that could arise. However, sir, we are also minded. We also very much move the Assembly, and I'm mindful of the comments from ministers that have also not only just been made, but I've also received whilst your ruling has been made. And on that basis, sir, I think possibly the best way forward is to seek leave to withdraw the amendment, sir, and to note that the council ministers will therefore not be opposing the unamended proposition, sir.
So you want the leave of the Assembly to withdraw the amendment?
If that's the best way forward, I think.
Is that
seconded, sir.
Seconded? Is the appel called for on that, or members content for the Chief Minister to have leave to withdraw the amendment?
Sir.
Yes. Yes, Deputy Pamplin.
Sorry, we failed to hear the rest of the Chief Minister's conclusion due to the foot stamping, which is always nice to hear. But if he could just repeat, because we missed his conclusion, if that's appropriate.
All right. I think he just said he wanted to withdraw his amendment. Don't think there's anything more to it.
Sir, sorry.
Well, forgive me, Deputy Young.
So, sorry, apologies for losing the flow, but Senator Ferguson needs to. Please, can you raise the defo on Senator Ferguson so you can participate in the votes?
Members content to raise the defo on Senator Ferguson. Yes, the defo is raised on Senator Ferguson.
Just a bit of assistance, I believe the Chief Minister indicated, sir, that your ruling and the subsequent advice from the Attorney General effectively confirmed what the amendment was seeking to achieve, and was therefore proposing the amendment is withdrawn. Thank you.
Yes. He needs the leave of the Assembly. Does anyone wish to, the members content to proceed on the footing that the amendment is withdrawn? Yes. In that case, the amendment is withdrawn.
Thank you, sir.
Back to the proposition as amended. Does anyone wish to speak on the proposition? Yes, Deputy Higgins.
No, sir, just actually to ask that the Attorney General still at some point come back and give us the answer to whether it's qualified or absolute privilege. I think we need to know that.
Yes.
Thank you.
Mr. Attorney, you ready to deal with that issue?
So, yes, I've only been able to look at it on my iPhone, so I can't give a full answer, but it is qualified privileged. I am aware that there was a ruling of the Information Commissioner in relation to a case concerning the toilet at St Lawrence Church, where the Information Commissioner did agree with the particular form of law officer privilege. And as I said yesterday, that form of law officer privilege is a special form of privilege in that it requires both the waiver of the person who's requested the legal advice and also the law officer who has given that advice. It requires the agreement of both of those to waive privilege in that advice. But in response to Deputy Tadier's question, it is qualified privileged rather than absolute privileged.
Thank you, Attorney. Does any other member wish to speak on the proposition? If not, then I call upon, Conataba St. 1.
Thank you, sir. Yes, and I'm very pleased that the amendment's been withdrawn, although it's taken up an enormous amount of the Assembly's time. And in my view, we should never have got to this stage in the first place, because I believe that this issue should have been sorted out privately between scrutiny and the government, and we shouldn't have wasted so much of the Assembly's time debating something that, frankly, is in many ways administrative. And I'm grateful for your ruling, sir, because that has clarified the position very clearly. I'd just like to re-echo Deputy Morrell's comments. I cannot believe how a scrutiny panel, and I have dealings with my scrutiny panel, who are extremely helpful, can function without seeing the minutes in an unredacted form. It's extremely difficult. And I think we just need to remind ourselves that scrutiny is here as our critical friend, not as an enemy, and we need to make sure that they have full information so that they can provide us with helpful advice, which sometimes we'll like and sometimes we won't. But nevertheless, at the end of the day, as government, it's our choice whether we accept the advice. But we need, I think, a check and a balance. And without the provision of these minutes, I think it would be incredibly difficult to do that job. So I shall be supporting the proposition. As I said, I'm somewhat disappointed that we spent so much time talking about it today when we could have been talking about things that are more important and perhaps more productive. Thank you, sir.
Thank you, Conrad. No other member wishes to... Oh, Deputy Tadier, you wish to speak.
Yeah, thank you, sir. I think this whole debate has shown that we are in a very delicate position when it comes to matters of transparency. If essentially what's being asked for here, I mean, it's not legal advice that was being sought by the scrutiny panel per se. They just wanted to have the access to information to do their job. And what is quite remarkable for me, trying to take a step back and perhaps look at it as a member of the public listening might also look at it, is that scrutiny don't want to publish any of this information necessarily, and so already there are already so many layers of protection in there, and what this tells me is that I think in the 21st century the presumption of openness and transparency about how decisions are made have to change, and I think that I understand that there are exceptional circumstances already when legal advice can be waived, and I can't resist saying that I hope that when it came to the matter of the St. Lawrence Church toilet, that the information helped flush out the truth in that respect. That's the first time I've heard the chair laugh, sir. You're too kind.
It's not the first time, actually.
But maybe one of my jokes, they say.
No.
And the point is, I'm not sure that I don't quite get this example. If information is qualified exempt, that must mean that the public interest must be applied. And if the public interest comes back in favour of full disclosure, not redacted disclosure, we can't simply say that there has to be some kind of quaint gentleman's agreement whereby both parties agree to waive their privilege. It has to be because the Information Commissioner tells whichever party that the information needs to be disclosed. And I think we have to get to that point, and I'm not just talking about legal advice here, but I'm not one of those who fully goes down the Deputy Morell point of view that there should be no safe spaces. I think I addressed that yesterday. But when the paradox is, of course, we really one legal advisor in terms of the office. We have, of course, the Attorney General and the Solicitor General, and I'm very grateful for the advice that they give. They're very erudite, and they're both, certainly I know the Attorney General better, but I know that they're also good individuals, so this isn't a personal criticism of them. But we have the paradox where, of course, if scrutiny managed to ask the same question by chance of the Attorney General, and that the ministers have asked as well, they can rest assured that they would hopefully be given exactly the same answer. But you have this kind of absurd, I look at it, call it absurd from a public accountability point of view, that you can't ask the Attorney General what question has been asked of him, and we're even told that you can't the ministers can't say whether they've taken legal advice, which is a bit crazy because we know that it's a functioning fiction, because of course you know that they're duty bound to take legal advice on issues that are contentious or likely to be controversial or possibly illegal, to prove to the Assembly and the public that what they're doing is lawful. So I think this whole episode has shown us that there does need to be a serious focus, and I don't know who the right people are to do that, whether it's provision and procedures or a special panel of scrutiny, and it may well be something that needs to be done after the next election, sir. But I think in order for this kind of debate to be avoided in future, it's really important that the Assembly knows that it can ask for full information when it needs it, because certainly that's what the Freedom of Information Law envisaged, that the public interest test should always be applied and that the public shouldn't have greater access to information than elected members who might need that information to do the work that they're charged to do, sir. So in summing up, I fully support this proposition about what the scrutiny panel have asked for, and I suspect it's been a debate which is focused on some niche areas which we didn't think we'd necessarily be focusing on so much. And I hope now that the scrutiny panel can do that work, and I thank them for the task that they've undertaken on behalf of the Assembly, sir.
Thank you, Deputy. If no other member wishes to speak, Deputy Guida.
Sir, we've talked about a few things here, and of course legal advice has taken a lot of this. But I'd like to come back to actually what is the essence of the problem, and that is the notion of safe space. When you discuss policy and development, you need to be able to do it freely. I'm going to digress quite largely, but don't worry, I will reach Judge's shores fairly soon. 6 months ago, I was offered an interview with the leading TV channel in France about fishing matters. The Minister of the Sea had just threatened to cut our electricity, and that leading channel wanted me on their prime hour, on their prime time, or offered the prime time, and then wanted to record an interview. And I spent a fantastic half an hour recording an interview with a French journalist who was learned and inquisitive and interesting, and we had a fantastic discussion. Sustainability, we want to maintain the fishing for future generations. Our problem is to maintain the effort, make sure that not double the number of French boats will come into our waters. We spent half an hour discussing extraordinary subjects and really going deep into the subject. At the very end of the discussion, he said, "Oh, the minister has threatened to cut your electricity. You must be worried." I said, "No, that's not terribly important. What's important is sustain." Wait. The minister has threatened to cut your electricity. You must really be fearful of that. No, that's not terribly important to us. What's important is that the negotiation... Sir, the Minister of the Sea has threatened to cut off your electricity. You must be in a panic. I said, listen, we've got generators. We'll fire them up. And all that we can hope is that the smoke will blow off over France. Now, which 10 seconds of the interview you think went on primetime 8 o'clock TV in the #1 channel in France? Now, I've been doing pretty much this non-stop for the last 7 days. And I must say, I absolutely hate it. On one hand, you have to be persuasive, you have to bare your soul, you have to be truthful, you have to be forceful sometimes. And on the other hand, you know that every single word that you utter may, and probably will, be used against you in exactly the opposite way that you've been trying to build over hours of conversation. Now, we're very careful of what we say here, because it is exactly the same thing. It is a public forum, and we're very careful. Most of us write down our speeches and edit them carefully to make sure that there's not a spare word, that there's nothing that can be taken out of context. We have Hansard that can prove retrospectively exactly what your speech was. And yet, sometimes little bits are taken off and used against us. And used, it's not against, it's the fact that it is used destructively. So it is actually quite important when you're building up policy, when you're having a discussion about policy, to have that safe space. I mean, imagine if we extended, the openness of the government to our homes. You have a discussion with your spouse, and that is going to be recorded because, that's important. My discussion with my spouse are a very, very strong base of my ideas on policy. Are we going to record them? I hope not, because I'd be lynched. I wouldn't make it out of this assembly. We have to talk about everything, and it's fantastic. We have this openness, this notion of being able to talk about everything. Now, I think that minutes in the Council of Ministers and in the competent authorities meetings are primordial, because it is essential that we keep access to those in case something serious happens. We may have an inquiry on what we did in CAM, and that would be legitimate. If you think that we've killed dozens of people in Jersey unduly, that we've not done our job, and you need an inquiry, well, let's have it. And they should have access to those minutes. But if you say in advance, those minutes are public, they're not going to be the same. That discussion will be very, very different. For starters, 3/4 of it are going to happen in the pub beforehand. And we'll come in and say, oh, we don't need to discuss this much, here's our decision. What scrutiny needs, as far as CAM is concerned, is the initial document, what was used to make the decisions, and the vote. What were the votes? To go into detail and say, wait a minute, somebody had to say, oh, what if we do nothing and will everybody die? Well, it's a question that needs to be asked, that needed to be asked. But how important is it to point out who said that first, how they said that, how other people reacted? That has nothing to do with the issue. The issue is we were given data and we made a decision. So we're going into things that are really not necessary here and that are taking away that safe space. And if there is an inquiry, well, half of that discussion, half of that process will be hidden anyway because we will stop having it, we will stop making it. Council of Ministers will last 15 minutes because we'll do everything outside of that. And I think that's wrong. I think it should be a free, safe space for everybody to discuss policy in design, policy in development, but recorded, because sometimes you do need to dig into it. If we start World War III with the French, somebody will have to look at why it happened, and we need to have that recorded, and we need to have those minutes. But the last thing we want is for our discussions on the negotiations, on the interaction, to be made public immediately. That is really, really wrong. Now, sir, I'm really sorry, but I think I must address the elephant in the room. Scrutiny should be a critical friend, and most of it is. And I must say that the panels I deal with are very professional, and I'm amazed actually because my personal panel, my own panel, sorry, personal, my ministry's panel is led by Reform, and they have shown fantastic maturity as a party, as politicians. They scrutinize, they do their job, they're extremely annoying, but which is fair. It is a necessary thing. It is really important. They debug my policy. They come back with things I haven't thought of. It is really good. It is really annoying, but it is really important, really, really good. They're doing their job. But not all the panels are the same. Some of our panels are destructive. They are the opposition. When Reform wants to be the opposition, they have a normal scrutiny panel that does its normal job, and then they come out as a party or as individuals and bring propositions. It's their propositions. They may be against the government, but it's their propositions. They are fair. They're not mixing up the two. And I think that's how it should be. Other panels don't do that. They bring propositions as a panel that are destructive, that are opposing, and that is wrong. So here, again, if we vote this, what is going to happen is that there will be less transparency. The data will not exist when it should exist, and there will be less transparency. So do be very careful when you vote this, please.
Point of clarification.
Sorry?
I wanted to ask point of clarifications from the previous speaker, please. Previous speaker, Deputy Gida, used twice that the minutes will be made public and public would know. I would like to ask from this previous speaker clarity that he recognized that the minutes that were requested, that proposition is requested, it's on confidential base to the scrutiny and not to the public.
Sir, actually, I disagree a little bit. I understand that the minutes will not be made public, but I also understand that scrutiny wants them to do something with them. They don't just want them to have a little, nighttime read. So if they do something with those minutes, that will become public. So.
Thank you. Deputy Young.
Thank you, sir. I think I'm going to change my speech after the last speaker, because I think what we just heard was an argument that we have a choice. We can either run on a party political system, or we can have a system where we work with scrutiny. We work in partnership with scrutiny, and scrutiny adds value. And so I think, that issue plainly emerged to me. Yes, party politics gives you robust debate, but I think this is a new thing for the Assembly. And I think when we consider the proposition, I think we have to consider it as we are structured now. If things are to change in the future, then okay, when we get the report from PPC about the way scrutiny and the ministerial system's set up, I think that will lead to a debate and changes. So I think that issue, I don't think that, with respect, I don't agree with my colleague on that, but we work very well together all the time. But I don't accept that, sorry to say. But on the context, so we have to deal with this proposition on its merits in our current context. And the context is, actually, I think we've kind of drifted off of this a bit. It was about the minutes of the competent authority ministers. Now, I've always had a problem with that group, not because I'm not on it, because frankly I'm pleased that I wasn't on it. But what I found really annoying in the last 3 years is that every time the competent ministers make decisions, the media put, the ministers have decided, the ministers. It is a subset of ministers, and on my understanding of its constitution, this is the key point, there is a proper constitution for it. And there needs to be, as Deputy Morell told us, and he's absolutely right, the structure and the whole thing under the Emergencies Council is not satisfactory. And, we are not out of this pandemic yet, but we're doing well. But we don't know what's ahead. And I think it's really important that, because we do need this inquiry, looking back. I don't know when it will occur, but we do need it. And there needs to be disclosure for lessons learned. So I think I would like to see commitment somewhere that we will have a look at that structure and get it right. Because the debate we've had about the legal complications, I think I've lost, a lot of that just went over my head. It was, such a really sort of focused discussion on the legal issue. But it seems to me that if you have a proper constitution, the constitution gives you the rules. And then if you've got a constitution with the rules, we all follow it. And we don't have that. And I think so the debate to me has illustrated further evidence that we do need to have a proper constitution of because what that body is, as my understanding is, it's the ministers that their laws already give them decision-making authorities on matters that are germane to an emergency, plus other invited ministers. And of course we knew that when we lost our former education minister. Former education minister was not included. And of course I'm quite happy that there is such a body, but I think what is difficult is not knowing on basis of what information and what decisions are made. And I think it's a perfectly reasonable proposition, which is in the spirit of openness and transparency. So absolutely, it's unequivocal for me. I'm going to support the proposition.
Thank you, Deputy. Deputy Higgins.
Thank you, sir. And I must admit, I found Deputy Guida's speech excellent, to be perfectly honest. And I know exactly what he means about the media. And again, I recently gave interviews to French media. And I always believe in being open, and I give my views as I do in this assembly. But at the back of your mind, again, you're always thinking about the editing. It's not just French media, it's local media. We all talk to the media, I think most of us have a good relationship with them. We don't know what they're going to use. And what can be a straightforward interview can be turned on its head. And so we all have to be very careful of the words that we use. Now, that's one thing. And I must also say, Deputy Guida, I hope you haven't got a smart speaker in your home, because Alexa was listening to your conversations with your wife. And it may get out that way. So be careful. I must also say that I've always been in favour of transparency. And in fact, many of the questions I was asking the AG, and I can remember going back to the FOI discussions in PPC 13 years ago, and we got experts over from the UK. I do believe in being as open as possible. But it can bite you being very open. And I can remember in my very first term, I was chairman of the Economic Affairs Scrutiny Panel. And we all know that scrutiny panels, as government, have private meetings and we have public meetings. And I was so enamored with the idea of transparency, the rest of the panel agreed as well, we decided to have no closed meetings. And so some of our private discussions were there, and a member of the public, a certain blogger, put everything we said out on the web. And you thought, because we were having private discussions about what we thought about the government policy and so on, and how we should tackle this, and some of our criticisms of it, and almost our thoughts were there. And I thought this person would be responsible. Obviously, I was very naive. And it all went on the web, and what did we do? We immediately went into private sessions when it came to discussing tactics and how we were going to go forward. Now, I can say as well, I personally have been very critical of the scrutiny liaison body. For a start, chairman of the scrutiny panel don't come back and discuss the issues with us and see what they're planning on doing. Now, our chairmen are on those panels. They should be discussing it with it. I've asked for it to be minuted on the scrutiny panel, that we get a report of what's gone on scrutiny. Oh, it's just the same old thing, such and such a person was going on about that. No discussion. And so decisions are being made in my name as a state's member, and propositions being brought, and I've never been involved or ever been asked my opinion. Now, that can't be right. So I am critical of part of what we do as scrutiny. I do believe in scrutiny as being a critical friend. I really do believe we've been doing that. Some of what's come out of scrutiny in recent years, I have to say, I think it's political. That's the way I view it. Now, I can be critical of the government, but I can also be supportive of the government if I believe they're right. That's my view. I'm entitled to my own opinion. But if I'm not being consulted and others are taking a different stance, I find that wrong. Now, what I will say, though, is that if we're going to ask as a general thing for the government, and by the way, I'm in two minds of this. I'm not even sure how I'm going to vote. I still have my views about openness and transparency. Are scrutiny also going to do away with their private meetings and their discussions? Or are their minutes going to be able to be read by the public as well? And as I say, after being bit once, I'd be wary about doing that if I was you. I'd think about it. You have your private discussions. Should governments, everything they say, be revealed? Should we have a dual, should we have the same standard for all, or what? So all I would ask is states members, just think about it. What seems to be a simple thing is not necessarily that simple. And at this point in time, I still haven't made up my mind how I'm going to vote for this. I probably will support it, but at the same time, we need to be aware of the consequences of these things. Thank you.
Thank you. Deputy Labby.
I enjoyed his speech too, but of course tonight's headline will be Deputy Guida starts World War III with the French. I'm so relieved not to be having to vote against an initiative to increase openness and transparency, and it would have been the very first time. I am concerned, though, that we are doing something we should never ever do in this assembly, and that is vote for something that means one thing but says another. We are going to release these minutes, and that's the right thing to do. And we're going to release minutes with, but taking out the legal advice or certain references to the legal advice. Where in the world does that mean unredacted minutes? Only in Jersey, it seems. Because what we're saying is this proposition says unredacted minutes, but and that's there in the law, but you have to go to the code and read the code alongside those minutes, and then it doesn't mean unredacted.
So it's not our finest hour.
Thank you, Deputy. Deputy Ward.
Thank you, sir. It's strange to be back in the Assembly standing up, because agreeing with Deputy Guida makes me a little giddy and it feels I might need to sit down again. So I'm a little bit taken aback there. But I'm really pleased that it's being recognised that actually on the scrutiny panel, and I don't disagree, I disagree with a number of things, but I disagree with one thing, which is that when he says, I chair the panel as a member of Reform, actually I've got to say, I know this is difficult perhaps for people to see, but I don't consider that membership of Reform is relevant to chairing that panel. I believe it's about doing a job on that panel, because there are a number of members on that panel. It's difficult, obviously, to get people are really busy and often can't attend the panel, so we have to make do a lot of the time. But there are a number of different voices on that panel, and you need to listen to all of them. And I would go as far to say, actually, it's good for me, because one, it gives different views, and second, it shores up my opinions when they're tested, so that I can bring forward ideas later on as a member of this Assembly separate from the panel. And I think a recognition of that role of scrutiny being separate from other roles is very, very important, because that's the process we're going to need to have whatever system we have in the future. And I disagree, sir, I'm afraid, with Deputy Young when I may have got the words wrong actually, but he said about you either have scrutiny or you have party politics. That's not the case. Go and have a look at assemblies around the world and you have party politics, but you have scrutiny. And it is a process that we have to go through. But then that's where my agreement ends, I'm afraid. The analogies with TV interviews and kitchen conversations, I think, are somewhat flawed. The media are there for a particular reason, and that is to just create a story, to sensationalise, to sell newspapers, to sell clicks on the website, let's be honest about it. And there is evidence, and if you research this, that on more developed democracies around the world, the reporting on political reporting on media is from the most senior reporters. And I think sometimes Jersey, and it's very dangerous to be critical of the media, but is a test bed at times for journalists, and they're cutting their teeth. And sometimes, you know, that's why we get to those situations of sensationalist reporting and so on. So it's not blaming, it's just pointing that out. But scrutiny isn't there to sensationalise or just to make a story. It's there to try and analyse and produce information and guidance. And I've got to say, recently we've been trying to do more with press releases and so on. It's been really difficult for these officers to get an agreement from us as to what we're going to put as a press release, because we go through that scrutiny process with the press release. And I know that those officers are just tearing their hair out thinking, I just want something simple to put out, and you're going through every single word and analysing the meaning of every word. Just give me something to put out. So it is difficult. So I think that analogy is false. And in terms of this safe space, a safe space for discussion is fine. And we have to go through ideas. But I think what helps scrutiny, and it is the scrutiny panel that will look at these minutes, is to see the development of these ideas. Because if you can see the development of ideas, you can see where perhaps errors were made in assumptions. And you can then say, look, was this an error in assumption at that stage, particularly around stacked minutes, for example? And can we suggest that this was the error and where it was made? And you're giving government a way out when you believe that there is something that isn't working. And so scrutiny can be incredibly constructive in that process by knowing that information. And I'm going to repeat something that Deputy Morell said yesterday, because I think we're losing track. Minutes are not a transcript. They are not a transcript of a conversation. They are a summary of what was discussed. And I'll say to Deputy Higgins, in terms of the minutes for meetings, they are online. The scrutiny minutes from our meetings are all online. You can look them up, they're here. I opened up the ones, the closed meetings, minutes that we agree in those meetings are all online for the public to see. There's full disclosure of them. And that's the sort of minutes that we're talking about. So, sir, I think this is a real step forward. And what I would go as far to say is that I would ask the government now to accept the proposition. I suggest in the word, in the spirit of transparency, in the spirit of saying, actually, yes, we have nothing to hide, actually in the spirit of we want the public of this island, and we're talking about competent ministers' authority here, the decisions that were made to remove the rights of people to do particular things. Let's remember what we're talking about here. In the spirit of transparency over those issues, we need the government to now say, yep, okay, we'll go with this. We'll go with this. Go with it. And you can see these minutes for scrutiny, and there's another check and balance in place for the population, and we will trust scrutiny with these minutes. So, sir, I urge members to support this, and I would say let's simplify this by the government accepting this proposition, and let's all move forward together, and let's have genuine transparency in this assembly.
Thank you, Deputy. Does any other wish to speak on the proposition? Yes, Deputy Lewis.
Yes, thank you, sir. I wasn't going to speak, but inspired by Deputy Guida's speech, which I thought was excellent. I think I would tone it down very, very slightly, in as much as obviously we must be open and accountable, but the minutes as such, they just give a flavour of what went on. It's not the exact detail which has been expressed, so it can actually be misinterpreted, you know, in the actual minutes itself. I said I've obviously seen I'm a member of the competent authorities. It's a very responsible job, which is not taken lightly by any of the members. I think we've had around 41 meetings since it was set up. I think the first one finished about 2:30 in the morning. It's very onerous, and we are very well aware of the responsibilities, which does weigh very heavily on us, and we're very well aware of the impact it has on the people of Jersey at large. But to say, I wholeheartedly agree with the sentiments of Deputy Guida, but I think because it just gives a flavour, the minutes give a flavour of what goes on. Obviously, it has been stated that the legal advice will be removed, which again is like, how can I put it? It's like giving somebody a recipe but taking out some of the contents. It alters things slightly, so I'm not sure what use it can be to people, but it will give a flavour of what goes on. And I think I would reluctantly, in the cause of openness, support it. But I think it could be misinterpreted, and I would advise caution. Thank you, sir.
If no other member wishes to speak, then I call upon Senator Moore to reply.
Thank you, sir, and I'd like to thank everyone who's taken part in this debate. It's been an awful lot longer than we had expected and anticipated, but at the end of the day, together we got to the nub of the issues and we've clarified them, which can only be a good thing, because ultimately that is part of the role of scrutiny in itself. So thank you all very much for taking part in some scrutiny in real time. I would like to offer a small piece of advice to Deputy Guida, both for giving media interviews and participating in meetings. It's generally not a good idea to make inappropriate comments during either of those occasions. That's my advice to you as a former journalist. For Deputy Higgins, there are SLC minutes provided for all scrutiny members on the All Scrutiny Members Teams channel. So you can read them at your leisure, sir. And I take the point. I think that we ought to have more conversation about what is discussed at those meetings, but there we are. That is a matter for another day, sir. This proposition came about following a recommendation of the Corporate Services Scrutiny Panel's COVID response report, the first one that we published in March, and our work looking at COVID and the response to that continues to this day, as does the PAC and their work on the same topics. So part of our job is to obviously follow up on recommendations that are made in our reports to ensure either, if they're agreed to, whether that happens, and sometimes when they're rejected, to follow up and perhaps look at it in a different way. So perhaps where some of the confusion about whether these minutes are intended for publication with the general public or simply for the scrutiny panel and their understanding of this particular and very important subject is because our recommendation in that report was that the government should make their minutes of competent authorities, emergencies council and STAC public within 2 weeks of each of those meetings. That recommendation was rejected, and so after some internal backwards and forwards and requesting the minutes privately under our code of practice to the panel, we sought the sort of, final straw, last possible option, which was to come to the Assembly and ask you for support in us having the ability to read the unredacted minutes, but under our code of practice without the legal advice contained. And so that is where we are today. It's a very simple request, but it is one that we believe is really vital to this particular piece of work in terms of being able to hold the government to account by understanding the conversations that have been conducted in those 40+ meetings of the competent authorities ministers. And so it's particularly important as the pandemic has affected every single member of our community. And ultimately, we are all here simply to represent those members of the community. And whilst the government prefers not to conduct a committee of inquiry at this time, then it is the job of scrutiny to hold the government to account and continue to do this work, looking at the COVID response in our work in scrutiny, which of course is an objective process, and therefore that is why collecting information and evidence throughout that process is an absolutely vital part of it. So I think that is all that is needed to be said at this point, and therefore I would ask all members to support this simple request, and I ask for the appel.
The appel has been called for. I ask members to return to their seats, and I ask the greffier to open the voting, which will include the placing of a link in the chat for those who are attending remotely. Greffier, are there sufficient links in the chat for me to close the voting? If all members have had the opportunity of casting their votes, I ask the greffier to close the voting. And I can announce that the proposition has been adopted. 28 votes pour in the chamber and 5 votes contre, and some additional votes pour on the link, which we believe makes a total of 37 votes pour and 5 votes contre.
May we have the 5, please, sir?
Yes.
Those voting contre, the Connétable of Trinity, Deputy Pinnell, Deputy Ash, Gida, and the Deputy of St Peter.
Sir, may I thank members for their support and their confidence in the scrutiny process.
Thank you. The next item is the draft employment amendment of law number 3 Jersey regulations P88 lodged by the Minister for Social Security. For the purposes of this debate, the main responder is the chair of the Health and Social Security Scrutiny Panel, and I invite the greffier to read the citation.
Draft Employment Amendment of Law Number 3 Jersey Regulations 2000. The states make these regulations under Articles 10.6 and 11.6 of the Employment Jersey Law 2003.
Minister.
Thank you, sir. And when I was first appointed as Social Security Minister, we actually, my assistant then was Deputy Southern, and we asked Jax to come in to talk to us, and it was about 0-hour contracts or the abuse of. And it was really interesting. 5 minutes into the conversation, the lady from Jax said, if you really want to do anything to improve the employment law, you need to look at holidays and rest breaks. And I said, we don't have them? Oh, I've been telling employers for years that they should be giving their employee a rest break. And it used to work, sir, because some of them didn't check our law. But, so I said, no. We absolutely will do that, and as soon as I completed Family Friendly, which took over a year, got moved out, got changed, but it got through. Everything got through in the end. I asked the forum if they would consult on daily rest breaks and statutory leave. Unfortunately, COVID halted the work in March 2021. No, it halted the work, but it came back in March 2021, and the chair of the forum sent me her report and recommendations, and then we sat down together and went through all the recommendations, explaining why, who she spoke to and why, because they consult so widely. And as I say, went through the details. The draft regulations we are debating today, if agreed, will come into force on the 1st of January 2022. And the evidence the forum gathered shows clear benefits for employees, periods of leave and breaks for rest and refreshment. These regulations will increase the minimum annual leave entitlement by a week and will introduce the daily rest break entitlement for the first time. So the amount of annual leave and daily rest breaks provided by employers varies. These regulations, if approved, will ensure that every employee receives at least 3 weeks minimum annual leave and bank holidays and the right to a daily rest break. The forum recommends 15 minutes, and, sir, I maintain the principles.
Are the principles seconded?
Seconded, sir.
Thank you. Does any member wish to speak on the principles? Deputy Hegra.
So I'd just like to say that it will be Deputy Pamplin that will be the lead in relation to the panel of Social Security and Health, sir.
Thank you. Does any member wish to speak on the principles? Senator Mezek.
Thank you, sir. It's simply to just very briefly say that in terms of the election manifesto that myself and my Reform Jersey colleagues stood on at the last election, we were absolutely crystal clear in this, in that we had a very specific manifesto pledge, which was that we would support 3 weeks minimum statutory annual paid leave, and therefore we can be delighted to be able to support this. And I only stand to make that point just to say that this is how politics is meant to be done, that you're clear about what you stand for before an election, and then you can hold that up to your constituents and say, I did what I asked your permission for me to do when elected. So I would thank the Minister for bringing this, and she has my and Reform Jersey's wholehearted support for 3 weeks of minimum statutory annual paid leave.
Thank you, Senator. Deputy Pamplin.
Thank you, sir. I'd just like to echo the words of Senator Mezek, and as a member of this Social Security panel, again, we worked constructively and in support of what the Minister's intentions, and our work here is to try and to support. And to echo the words of the Constable of St. Juan earlier in the previous debate, it's a relief to be debating something that will benefit the people who put us in this assembly, the lives of many voters and workers of this island. The Health and Social Security panel did produce some comments paper separately to the amendment we'll get to very shortly on the breaks part. We did provide a separate comments paper on why the panel didn't seek to bring an amendment to the increasing of the statutory annual leave entitlement. We did consider it, so I just thought it would just be prudent to just go through the comments and notes for members of the public and the members who have not maybe read them in full. The panel received a report by the Employment Forum, which had been produced, as the Minister stated, following public consultation on the current level of statutory annual leave entitlement, and the issue of rest breaks, which we'll get to, and the proposal that the Minister is bringing today increased to 3 weeks. The panel was surprised to learn that 2 weeks plus bank holidays was the statutory minimum for annual leave, and was pleased to note that the number of employees offer their employees more on this island, which is to be commended to those employees on this island who do that. This is just a welcome tightening up to support others who should be, we believe, and I think the Assembly, if they vote for this, will also. However, on the review of other jurisdictions section of the report by the Employment Forum, the panel noted that the statutory annual leave proposed by P88 would still be below the entitlement offered by some jurisdictions. For example, in the United Kingdom, the annual leave entitlement is 5.6 weeks, which includes bank holidays. For a UK employee working 5 days a week, 5.6 weeks is the equivalent of 28 days. If P88 2021 is adopted, and we hope it is, a Jersey employee working 5 days would be entitled to a minimum of 15 days, plus 9 for public and bank holidays, totaling 24 days. The panel therefore did consider the wider benefits of annual leave businesses and their employees, namely benefits to well-being and a good work-life balance, providing good quality of life. And as we've all experienced over the last 18 months, a lot of re-questioning of that has been highlighted. Whilst acknowledging that P88 would provide an improvement to the minimum requirement for the annual leave, the panel considered that there was still further room for improvement. The panel therefore considered lodging an amendment that would increase the minimum statutory annual leave entitlement to 3.6 weeks. For an individual working for 5 days a week, the 0.6 of a week would equate to 3 days. The proposal to add 0.6 weeks, as opposed to specifically stating 3 days, would have made the entitlement proportionally equal for all employees, regardless of the length of the working week. However, after further discussions, the panel recognised that the changing of the statutory holiday entitlement to a proportion of the week would cause wider implications for employees. Article 11.4 of the law states where the period of leave to which an employee is entitled is or includes a proportion of a week, the proportion shall be determined in days, and any fraction of a day should be treated as a whole day. So therefore, the panel understands that if entitlement to a fraction of a day is rounded up to the whole day, it could have had unintended consequences. For an example, an employee could be paid more than they might be entitled to in the remuneration for annual leave. This would also have an unintentional impact on the employer, who would potentially have to pay an employee more than expected. The panel therefore were mindful that the amendment it was considering would not be inequitable because of the current wording of the law. Per Article 11.6 of the law, the States Assembly is able to amend the period specified for statutory annual leave for regulations. However, a change to Article 11.4 would require a change to primary legislation. This would take time and would delay the introduction of any increased entitlement to employees. Therefore, in the interest of improving the minimum statutory provision of annual leave at the earliest opportunity, which is why we're here today, the panel has decided not to lodge that amendment, which would further increase statutory annual leave at this time. Echoing the words of Gregory Gilder earlier, we did not want to wreck anything today. The panel is supportive of the element of the Minister's proposition that will increase the statutory annual leave entitlement to 3 weeks, but wishes to record its hope that the Minister or any successor to that post will be mindful to review the statutory annual entitlement again in the future, and there is not such a lengthy period of time to bring us still way short of most other jurisdictions, but it is a welcome proposition, and the panel supports that part of the proposition, and we will speak to our amendment shortly. Thank you, sir.
Thank you. Deputy Tadier.
Thank you, sir. The first thing I will do is echo what Senator Mezek has said already, that we know that this was a Reform Jersey pledge, and it's nice for us to be able to deliver on our policy, even when we're no longer in government. And I don't say that to detract from the work that Deputy Martin has done, because clearly what we saw here is that Deputy Southern, even as an assistant minister with Deputy Martin as his minister at the time, got to work very quickly. They had a meeting to look at one of their shared areas of interest, which was the abuse of 0 hours contracts. And as Deputy Martin said, when they got into the meeting, I think it was with Jax, she said, and they said, oh, we'll actually consider raising the statutory entitlement for leave, but also making sure people have their correct break times. The point is, it goes to show what can be done if you have progressive politicians in areas of influence and in ministerial office. Let's hope we have lots more progressive members in the Assembly and in ministerial office after the next election. I'm also reminded about that little anecdote that Deputy Martin said when she went to the meeting, and the person said, actually, if you want to make the change, you don't want to do it like that, you want to do it like this, about the Harry Enfield sketch and the character who always says, you don't want to do it like that, you want to do it like this. And I think that's possibly what I'm going to say, to fully support what's being proposed. But in fact, that we do need to look at this, it can't be the end of it, it's got to be the beginning of the progressive work we want to do when it comes to employees, workers' rights in the workplace. So, for example, I think it's important that we keep going, that the actual statutory leave is increased to what we would expect it to be, to keep us in line with other more civilized countries in the world. But what I'm also concerned about is people who have to work very long hours, because it used to be the case that you would either get paid overtime, and I remember my father, who brought us up as the only real earner, I suppose, in our family. My mother did very meaningful work at home looking after us and took on the occasional cleaning job or other job to try and help balance the books. But I remember manual workers back in those days when my father was bringing us up, he said that he often relied on the overtime that he would get to help pay the mortgage and to help pay the bills. And overtime, of course, was paid at a different rate. It was paid usually at least time and a half, double time, if you had to come in at weekends and on Sundays. And what we've seen recently, in recent years, is an erosion of that presumption by employers, where overtime is expected, first of all, and it's expected that you will do overtime at a flat rate. I don't think that's right. I think that if overtime is given, it should be paid at a higher rate. And I think that the Minister also needs to now look at what the maximum reasonable workload is for somebody in a week. Because ultimately we're looking at productivity more generally, not just in her department, but with the Economic Development Minister. And it doesn't seem right to pay somebody, as I've seen, to do perhaps a 70 or 80 hour week at a flat rate of pay, when in fact you could be taking on a second person to do that second job effectively. It means that the first person gets some proper leisure time, and it also means that there's more work for somebody who perhaps can't find work or who doesn't have that work. So why I welcome this particular proposition, because I understand we can't just talk about counterfactuals and things that aren't in the proposition. I was just offering some hope that this isn't the end of the road, is that this does provide some comfort for people in all sectors. Because whilst it is true that many employers, whether if you're lucky enough, I say lucky enough to work for the states, or if you're lucky enough to work for a big employer, perhaps in finance or in another, let's say, an office setting, or indeed telecoms or one of those well-established big firms, you will get generally very good terms and conditions. But if you work for smaller, perhaps private companies, then you're more likely to be making do with just the current 2 weeks of leave a year, even though you might be working very long hours for the rest of the year. But what is also true is that we know that there's been a tendency for people, again, an expectation that people should be working through their break times, that they should be working through their lunch times, that they should come in early and that they should leave late without necessarily expecting to get any paid for that. We know that, of course, that happens in some jobs where a salary is paid, but where you're on an hourly wage, I feel very strongly that people should be getting paid for the work that they're doing, and that workers shouldn't be doing any voluntary work for their bosses. So, and that is something that applies and that I've heard about from people in every sector. And as we move towards more family-friendly legislation, there are those who sometimes legitimately, I think, ask the question about, well, what about me as a perhaps young professional who doesn't have a family, and what about my statutory break time? So I'm glad that the Minister is bringing this today, and I think it shouldn't be the end of the road, but it should be the beginning of it. Thank you.
Thank you, Deputy. If no other member wishes to speak on the principles, then I invite the Minister to reply. Minister.
Thank you, sir. And I'm very pleased that Reform will be supporting this. As I said, it's something they wanted to achieve, and it's been achieved, and that's really good. I hear what Deputy Pamplin has said, and thank him for the remarks. He's supporting this bit, and they've looked, they've looked at the employment forums report, etc. Deputy Tadia, well, and to all of those speakers, I've started to write a legacy report, and this is in it, will be in it. Don't leave it more than 2 or 3 years. In fact, 2 years, I would like this revisited. I mean, a new minister may have a completely different idea, but we've not changed it. The 2 weeks has been there since I think Deputy Sutherland, I brought the employment law around 2004. Well, we were in the Assembly when it came in, and it stayed the same. So that is going in my legacy report. I think I heard mainly all of Deputy Tadia. I listened back, but there were some really good points. Again, they could go in my legacy report. Working conditions, working hours. But do remember, I know people are not having lunch hours, but we also have now introduced flexible working. So sometimes it suits people. I used to work right out at Rue de Pré, and they give me an hour, sir. What would I do for an hour at Rue de Pré? I didn't have a car, couldn't get to town, but I had to have the hour. There was no flexibility about it. But if now I was working there, I could have 15 minutes, and finish an hour early. Anyway, I will definitely put that all in my legacy report, sir, and I maintain the principles. Thank you.
Thank you. Is the appel called for, or do members wish to adopt the principles on a standing vote?
Appel, please.
The appel has been called for. I invite members to return to their seats, and I invite the greffier to open the voting. Both in the chamber and on the link there, on the chat there is a link. Are there sufficient chat votes on the link for me to close the voting? If all members have had the opportunity of casting their votes, I ask the greffier to close the voting. And I can announce that the principles have been adopted unanimously, 38 votes for. Deputy Lehegerat, does the Social Security panel wish to scrutinise this matter?
No, sir.
Thank you. We now move on to second reading. Minister, there is an amendment lodged by the scrutiny panel to Regulation 2. Are you not accepting that, or are you accepting that, just so I'm clear? That's not accepted. In that case, we move to the regulations. Minister, it's convenient, I think, firstly, for you to propose the first regulation. Do you do so? It doesn't really say very much, but we need to come on to Regulation 2, the amendment, separately. Do you wish to propose the first regulation?
Yes, sir. I propose the first regulation.
Yes. Forgive me?
Seconded, sir.
Seconded. Thank you very much. Does any member wish to speak on the first regulation? Thank you. Can we record that the first regulation is adopted on a standing vote? Minister, do you propose the second regulation?
Yes, sir. I propose the second regulation.
Is that seconded?
Seconded, sir.
There is an amendment to the second regulation lodged by the Health and Social Security Scrutiny Panel, and I ask the Greffier to read the amendment.
Regulation 2, in paragraph 3, in substituted paragraph 1A, for 15, substitute 20.
Deputy Pamplin?
Thank you, sir. So again, the panel notes that P8821 has reflected the recommendations provided to the Minister from the Statutory Annual Leave Entitlement and Working Day Rest Breaks of Jersey report. The panel recommends, to reiterate the point, the proposition to increase the statutory annual leave entitlement and also to introduce the requirement for a rest break into the Employment Jersey Law 2003. However, this amendment seeks to increase the uninterrupted rest period of no less than 20 minutes to each continuous period of working no less than 6 hours. The panel is supportive of the introduction of the rest period into the working day, but would like the entitlement to be set at this minimum to ensure that employees are guaranteed a break for that amount of time if they are to work for a period of 6 hours or more. The panel highlights that the proposed change will not specify, really importantly, whether this new rest period is paid or unpaid if this amendment that we're presenting is adopted. This aspect will be left to the individual contracts of the employment between the employer and the employee. But the panel believes that 20 minutes is more appropriate of a minimum rest period compared to the 15 minutes for a number of reasons, which I'll break down for members. The survey undertaken by the Employment Forum specifically consulted with a reference to a 20-minute rest break. The panel believes that the response to the following question supported the 20-minute rest period, and I quote, "If the employment law is amended to require a 20-minute unpaid rest break during the working day, should it apply where employee has worked for? Answer choice, 6 hours or more in a day, where the response received 60.4% of the 183 responses. Answer choice, more than 6 hours in a day, only received 14.19%. The majority of respondents to the survey felt that it would be suitable for a rest break of 20 minutes during a period of 6 hours, or more than 6 hours in a day. The Minister for Social Security's instruction to the Employment Forum had been to consult on amending the employment law to provide that all employees in Jersey should be entitled to take a 20-minute unpaid rest break in each 6-hour period worked. However, the subsequent recommendation from the Employment Forum had been for a 15-minute rest break, despite what I just highlighted. The panel acknowledges that the Employment Forum received a variety of responses covering a diversity of arrangements in the consultation and notes that the report references a number of comments about the importance of flexibility rest periods, as the Minister mentioned earlier, to some employees and the terms agreed in individual employment contracts. However, the report does not specifically outline the scope of data and detail all the responses received that led the Forum to recommend the rest period of 15 minutes. Other than stating, the members of the Forum have decided to recommend a 15-minute rest break in a working period of 6 hours or more, rather than 20 minutes, because after studying the responses to consultation, the former appears to be at the level most frequently operated by businesses in Jersey. The panel is of the opinion that an uninterrupted rest period during the working day is of a great importance to the well-being of the employee. The panel acknowledges that each job will be different. However, is of the opinion, the panel, that a rest period should provide the employee with sufficient opportunity to take time away from their workspace to check their own well-being, mental and physical needs. Whether this is to take a comfort break, have some food, get a breath of fresh air, make a cup of tea, take a screen break, sit down, take a walk, go inside, whatever they choose to do in their break, an extra 5 minutes could make a big difference to somebody's mental health. The panel notes from some of the responses quoted in the report that a panel of employees recently already receive and employees provide more than 15 minutes rest periods during the working day. However, the panel feels that introducing an entitlement to a rest period in the employment law is an important point in principle, especially for the employers who do not already benefit from a rest period from the terms of their employment contract, and the setting a minimum time of 15 minutes would not be symbolic of best practice. The panel noted that both the United Kingdom and Northern Ireland are examples of jurisdictions where a rest break of 20 minutes is entitled if the employee is working more than 6 hours. This amendment would bring Jersey in line with that benchmark. And also I would state the Isle of Man, which has a break of at least 20 minutes. Gibraltar, another island, has exactly the same. And Bermuda, another island, which actually has a 30-minute rest break after 6 hours, including a 15-minute break to be included if a worker's not taking that after 4.5 hours, to give some geographical small island context of where this amendment would put us alongside. As part of this amendment, the panel also considered proposing a further increase to the statutory annual leave, as I outlined earlier, but we decided against that because of the delays that could and the complications that would arise with the law drafting. This doesn't seem to be the conclusion of this panel for this, as we believe this is the right thing to do at the right time. And our final points on this was the well-being of islanders after the last 18 months has never been more critical, as we try to encourage people to continue the rise of productivity in this island to work, as many people on this island want to do. But we must understand that the world has changed in the last 18 months. And we believe, just though it seems like a small change for a large amount of islanders, will make a huge difference. And I propose the amendment.
Deputy Pamplin, there's a point of clarification from Deputy Tadier. Deputy Tadier.
Of course.
Thank you, sir, and thank you to Deputy Pamplin. The question I have is around the unpaid 20-minute break. First of all, could he clarify? He mentioned other jurisdictions, whether the panel considered that the break should be paid rather than unpaid, and did the panel or he have concerns that if the break isn't paid, as is being proposed, that then there's a risk that some workers would feel perhaps pressured financially to not take breaks because they couldn't afford to lose that part of their wages in order to have an unpaid break.
Thanks, Deputy Tadier, and he's quite right to highlight it, and we did, of course, think about that. And as I said at the beginning of my introduction to this amendment, we highlighted that the proposed change that we're bringing does not specify whether the new rest period is paid or unpaid. This aspect will be left to the individual contracts of employment between the employer and employee. And this is why we are in support of the Minister in bringing these, both parts of what she's bringing to the Assembly today, because this is something that should have been in place a long time ago and will go some way, we believe, once passed, to start doing the things that Deputy Tadier has mentioned. However, we just think to get this through today, this is enough to do that, and then coming forward we could start work on the things that Deputy Tadier has mentioned, but I hope that was helpful.
Thank you. Is the amendment to Regulation 2 seconded? Yes. Thank you. Deputy Masson.
Thank you, sir. Sir, the panel's amendment isn't something that we can support at this time. The Employment Forum carried out a detailed consultation exercise, and its conclusions and recommendations are clear. I hope members in preparation for this debate have read the Forum's 53-page report. The role of the Forum is to provide expert, dispassionate advice to ministers, and it has done that for many years now. I cannot recall a time when recommendations made by the Forum were rejected by this Assembly. Sir, The panel's amendment is not based on such careful analysis. The evidence clearly shows that a 15-minute break is provided routinely by most employers in Jersey, and currently that it's a split of around 40% paid rest breaks and 60% unpaid rest breaks, as demonstrated by question 31 in the forum's report. What is important for members to note is the answers to question 27. Would some employees lose pay where their work and finish times remain the same, but the employer deducts 20 minutes from their pay each day to accommodate an unpaid break? 54% responded yes, 28% responded no, and don't know was 17%. So it's clear that if adopted, the scrutiny panel's amendment for some employees who currently have paid breaks, this would flip to unpaid breaks unless contractually protected. And we don't know how many have contractual protection. The panel have no evidence, and scrutiny is supposed to be an evidence-based process to demonstrate whether employees support this change when framed in this way. In addition to this, I'd like to draw members' attention to question 26. Would some employees have to work an extra 20 minutes, brackets unpaid, close brackets, each day to get the same overall pay? The responses were yes, 41%, no, 42%, and don't know, 16%. So adopting the scrutiny panel's amendment for some employees will mean that some take-home pay will need to, so in order to get the same take-home pay, some will need to work extra time unless their employment contract states otherwise. Again, where is the evidence from the scrutiny panel to demonstrate that when framed in these terms, employees want this change, and where is the evidence to say that the panel's amendment won't have a negative impact on employees? There is no wider evidence or analysis provided by the scrutiny panel to support their amendment. I would remind members that the law we are debating today is for unpaid rest breaks and not paid. Again, as the rapporteur has said, that is a matter which is contractually decided between the employer and the employee. Also, comfort breaks and lunch breaks are not included in this. The forum, in a letter to the scrutiny panel, concedes that this wasn't made clear during the consultation exercise, or as clear as it could have been. This did lead to some responses saying that a longer rest break was needed to support lunch breaks. Again, I'd like to make it clear that comfort breaks and lunch breaks are different and not for the purpose of this law, as the Minister has made clear in the comments responding to the scrutiny panel's amendment, which members would have read. I did challenge officers and the Minister as to why we couldn't just accept 5 additional minutes in unpaid breaks. However, after being drawn to the relevant sections in the forum report, I am unable to support an amendment which, according to the feedback provided to the forum, would flip paid breaks to unpaid breaks and cause employees to work extra time in order to receive the same level of pay, as evidenced in the forum's report. To change the recommendation of the forum will now also place an additional burden on businesses who may have already anticipated changes from the 1st of January and planned accordingly. We are taking the first steps today in legally establishing these rights by granting unpaid rest breaks. We do not rule out further increases in due course, and the Minister has made a commitment to keep this under review. I would urge the Assembly to reject the scrutiny panel's amendment, support the regulations as drafted, and support the work of the forum. Thank you, sir.
Thank you, Deputy. Deputy Higgins.
So can I ask a point of clarification?
A point of clarification, if you'll accept it, Deputy Masson, from Deputy Ward.
No, thank you, sir.
Thank you. Deputy Higgins.
Thank you, sir. I'll be very brief. I'm going to be supporting the amendment. And what I do hope is the employers out there who claim this will be onerous are going to have to take into account the current labour market in Jersey and the fact that we're talking about increased shortages, people can't get people, and if you don't treat your employees properly, they'll walk. And I strongly recommend they do if the employers don't give them proper breaks and paid breaks. Thank you, sir.
Thank you, Deputy. Does any other member wish to speak? Deputy Southern.
I wish I didn't have to speak or feel compelled to speak, but here we are again with a return to the lowest common denominator. Worse practice supported by a minister than is suggested by this amendment. I'm almost speechless that this should be the case. I will wholeheartedly support 20 minutes over 15 minutes and abhor any practice that says otherwise.
Thank you, Deputy Senator Mezek.
Thank you, sir. And we'll be arguing over 5 minutes, essentially, for working people in the island who, let's face it, in recent times have had a rough deal as it is. The rights that working people have at work in Jersey have lagged behind other jurisdictions for a very, very long time when it comes to things like parental leave, when it comes to things like annual leave. And now we're going to be asking for us to continue to lag behind other jurisdictions like the UK when it comes for these rest breaks at work. I don't think we should be arguing about 5 minutes. I think that we should just go with what was originally put to consultation, which, from what I can see from the scrutiny panel's report to their amendment, had majority support from those who engaged with that consultation. I can see only a quarter of those responding said that a 20-minute rest break should not be introduced. So I think in this day and age, after the few years that we've had where pay for the lowest paid in Jersey has fallen behind, where real terms earnings have continued to be frozen, where many people feel like they're facing a cost of living crisis in their lives, that to support something that ultimately will support the well-being of people at work, it just staggers me that that would be something to argue about. And just one final point, sir, to refer back to what I'd said in the debate on the principles for this law, where we had said in our manifesto that we'd support 3 weeks of annual leave, and of course we'll do that and vote in favour of that. We said nothing on rest periods at work. We were silent on that, and I think when you are silent on an issue like that at elections, that's when values come into it. What is it you actually believe in at the end of the day? Do you believe in trying to make life better for the people you represent? Or will you take what I think is a weak political position of allowing ourselves to lag behind and to not support those basic rights which have been hard fought for and won in so many other places, and to say to Jersey workers, you're not as good as those in other jurisdictions and you don't deserve that right. So I strongly urge the Assembly to vote in support of this amendment from the scrutiny panel and do something nice for the people that we represent for once.
Thank you, Senator. Does any other member wish to speak on the amendment?
So, Deputy Tadia, I'm not sure if you've seen my request.
Oh, yes. I think I saw the light of the Minister first. Do you want to speak on this one, Minister? Minister, do you want to speak on this? Well, I saw your light first, but I'll ask Deputy Tadia to speak. Yes, Deputy Tadia, do you want to speak now?
I'm glad somebody's seen the light, sir. I hope that Deputy Masson sees the light at some point. I was baffled by his speech because he was saying that there's a risk that if it's a 20-minute break, then employers may not pay that, but if it's a 15-minute break, that they would pay a 15-minute break. Let's put it into perspective what we're arguing about. Somebody on the minimum wage here, those are probably the ones who need the most protection, the ones who are least likely to be working for big companies or companies with practices which are long established. We're talking about 5 minutes or 75p roughly, and that might be 75p that they're giving up of their wages voluntarily to have a 20-minute break rather than a 15-minute break. So given the fact that the law is silent on whether or not the breaks are paid, as I understand is the case, we're not saying it's a choice between a 20-minute unpaid break or a 15-minute paid break. Were that the case, I would opt for the latter, because that's more tangible of benefit to the worker. It's about whether the worker wants to give up potentially another 5 minutes of their pay in order to have an unpaid break. And if the employer is willing to pay for the break anyway, we're talking about 5 minutes of recharge time where the worker can have an extra 5 minutes and they might get paid an extra 75p. Who knows, they may get paid a full pound for doing nothing if they're on the living wage. But they'll probably feel much more relaxed and they'll be able to chat to their co-workers. Now, the reason I feel quite strongly about this is because whilst some people say, oh, you never, they don't necessarily say it to me, you know, they say to people, oh, politicians have never worked in the real world. I remember from personal experience, my first, I guess, proper paid job, if you like, was working at the tills and stacking shelves for the Co-op, sir, at 2 stores in St. Peter's. And I was paid £3.30 an hour, and I was given, like everyone else, a 15-minute paid break once you had completed 3 hours of work, so long as you were on a 6-hour shift. And what I would do, I would go to the canteen. I would probably either buy a sandwich there, or more likely I'd take something with me. I'd have a cup of tea. You have time to boil the kettle. You have time to do that. You don't want to drink your tea when it's boiling hot, because that's not good for you. You might burn your mouth, you might scald your mouth, and you want to be able to digest your food and speak to your co-workers. That's good practice, it's good for the company. You might also wish to take a comfort break. And I think you can do that in 20 minutes, much easier than you can in 15 minutes. And if we do go for the more parsimonious, lower threshold here, again, bearing in mind, like I've said, we're talking about unpaid breaks here, effectively, then I would simply encourage workers to make sure they take a loo break on work time. So don't go to the toilet on your own time, and make sure that you take at least 5 minutes, because you don't want to rush yourself and give yourself a hernia, because you wouldn't be of any use for the employer, sir. So has it come to the point where we've got a minister who's prepared to give an extra week of paid leave to these workers, perhaps, you know, with the worst current terms and conditions available? And it's remarkable, sir. I was expecting some members of this state to vote against that, because where were the people who stood up and said, but how is this going to affect small businesses to actually have to pay for an extra week of leave? It's fine if you're a big company and you've got lots of profits. What if you're a small painter and decorator? Where are all the champions in the Assembly for those small businesses to have to cough up for an extra week of pay? Yet when it comes to deciding about 5 minutes of unpaid leave, this is the sticking point. The minister can't do that. It's too rich for her blood. It's presumably too rich for the majority of states members. I don't think this should be the issue on which the disagreement happens. We've already found unanimity on the fact that we need to upgrade and level the playing field upwards. And I think the way we do that and send a strong message out today is that if you want to take a 20-minute break, and it's unpaid, and if the employer's happy for you to pay for that, then by all means, let's let people have 20 minutes during a 6-hour shift, sir. Thank you.
Thank you. Deputy Martin.
Yes, thank you, sir. And I am sorry that I can't support this, but I had sent out the forum and I asked them to consult on rest breaks and holiday entitlement to leave. And I did mention, I said, 20 minutes. And obviously they went out, they speak to everybody, chamber, IOD, everybody. They've got employers and employee representatives on the board, on the forum. They've got union reps. And they went around and then, and they brought me the report, and I sat down with them and go through the report, and everyone who is given a break, and Deputy Pamplin and the whole panel unfortunately misunderstood the breakdown, and the forum even wrote to them and said, you've misunderstood the breakdown. The majority of paid or unpaid breaks are 15 minutes. Been doing it for ages, it works, And, you know, that's exactly where it is, so 15 minutes. So, and again, what is scrutiny? I said when I went in, I said, do you want me to move this debate back? Because if you really feel it's 20 minutes, you do some research on it, go and talk, you know, do we have a call in for evidence, etc.? No. And the only thing I heard from Deputy Pamplin was, well, they do it in the UK and they do it in Northern Ireland. Yeah, that was in the report, they do. But we're starting today on something that I don't want to make it worse for workers. Already, sir, the big supermarkets, retail, hospitality have all got their shifts ready for Christmas and New Year. But don't worry about that. These are workers who are working there. All got them ready. Now, this comes in on the 1st of January. They've worked with 15 minutes, and we say to those, the majority are already doing it, and then the majority will do in 15 minutes. The split is half and half, sir, who's getting paid. Some are not getting paid, some are getting paid, but they've been doing this, worked around that. It's what my assistant minister said. If you flip from 20 minutes, you disrupt all those shift patterns and everything that are all ready arranged. What would I do as an employer? Oh, I won't pay the extra 5 minutes, or maybe I've got to do all this, completely change the shifts. I might not pay any of it. So I'm in that dilemma. So it sounds like 5 minutes. Now, if scrutiny had done a different piece of work and came up with a different conclusion from the forum, who have been doing this for years, who all industry, after me doing the consultation on minimum wage, industry want the forum back because they know them, they know the questions they ask, they're very thorough, and they go back and they deliberate over, you know, in the minimum wage, it's a couple of pence here and there. This was 5 minutes. And to keep people doing the jobs that they won't lose money, the starting point, they said, should be 15 minutes. So that's why I accepted. I'm not being all the minister can't give another 5 minutes. Rest breaks, toilet breaks, I think we contacted Jack's. People go to the toilet, sir, when they need to go to the toilet. They don't sit there for 6 hours waiting. Supermarkets, you close your lane, you go to the toilet, it is what it is. And screen breaks, that comes under health and safety. You can't sit at a screen forever and ever. I mean, we do. we work for ourselves, but we can. But there are rules, so I don't know what they're trying to cover. But what annoys me, sir, we're always talking about we want to do best for the people out there. And it doesn't affect me, sir, today if they pick 20 minutes or 15 minutes. In fact, it doesn't affect anyone in here, does it? Because we get paid once a month at the end of the month, ever many breaks we take or ever many holidays. But this will affect a lot. We have 340 jobs now. So if they're not, all right, may not have that many workers, but let's say, 55,000 workers. Anyway, it's just one of those, sir. The forum done loads of research over a good few months, spoke to Chamber, spoke to everybody, and they came back with this because a starting point for less disruption to people not lose money, let's start with 15 minutes, it will work. So, and they went through it, all the ups and downs for me. And as I say, sir, when scrutiny lodged their amendment, they even wrote to scrutiny and said, you misunderstood. The breaks that you're quoting included lunch hours. They did say, it might have been better putting it in a different question. But they in the letter, they have actually put down employees, so this is representatives or employees, 24 responses received which show the break period of up to and including 15 minutes. And 5 responses showed a period of 20 minutes. And also the 20 minutes, you will be getting 20 minutes if your HR department is a UK one, because they follow the UK law. They were having a problem, sir, when I made the family friendly more than the UK, because they was more at one point. And I said, no, I don't care what you do, you follow our law. If you're more, you can follow your law. And if our law doesn't provides more, you follow our law. So, you know, we overcome that. But I'm not here today, sir. As I say, it doesn't affect me or anyone in this assembly. 20 minutes, 15 minutes. I want to make it better for everyone who's not entitled to a statutory break at the moment. It isn't stipulated to be paid. It's about half get paid and half don't. But if you say you don't know if it's going to be 20 minutes and you've got to change everything else is going on, and they'll just say, oh, it's 20 minutes. Big government said we've got to give people 20 minutes and we're not going to pay them now. On a minimum wage, that's about 15 quid a week loss. And we don't know, because as I said, the forum, who is respected by businesses, unions and everything, went out and discussed it, and they came back with 15 minutes. Scrutiny read the report and thought 20 minutes would be better, but didn't. I would have pushed it back. I asked them to push it back, could have put the date back, could have come in April. Do your research. Come to me and say it won't affect those people if you flip it from 15 to 20. You can't. They can't, sir, because they haven't done the research, which is very disappointing. I like my scrutiny panel. We've always got on well. I always give private briefings straight away. They see everything first. They didn't even speak to me and say, what do you think the forum meant? Could have spoken to the forum, sir. But we are where we are, sir. As I say, today it will go one way or the other. It won't have any effect on anyone sitting in here, sir, because we get paid differently and we take our breaks when we want to. But think of the people you're always saying you're trying to help. If you're not sure, 15 minutes, 20 minutes, if you're not sure 20 minutes makes them much worse off, don't go for the 20 minutes. And so, again, I won't leave this. That will go in my legacy report. I want all the employment laws to be looked at by the next minister because this minister's sort of running out of time, that Deputy Tadeo sings, rest breaks, and maybe next time when we know the economy is going way up again, I would stipulate they're all paid breaks, sir. Absolutely. But you can only, you take employers with you at your pace, and then you don't hurt the worker as well. Thank you, sir. I maintain. Well, I'm just speaking, sir.
Thank you, Deputy. Yes, Senator Moore.
Thank you, sir. It appears that scrutiny and the objective process that scrutiny panels perform is a matter of some discussion and perhaps lack of clarity today. So I simply wanted to speak very briefly in support of the amendment and to remind the Minister that, and her Assistant Minister, that the Employment Forum's consultation was in fact silent on the time period, and the scrutiny panel have simply looked at the practice in other places and used that to inform their thinking behind bringing this amendment. And I hope that helps her in clarifying the position.
Conor Tarbison-Brillard. Thank you.
Thank you, sir. To be honest, I don't think government should get involved with this at all, but if they have to, be realistic. I, sir, have employed a small number of manual workers all during my working life and have always given a 20-minute break mid-morning. It takes that to boil the kettle, drink the tea, eat the sandwich, and have a comfort break. And I would agree with Deputy Higgins in his comment that if you don't look after your workers, you don't deserve to have any. I conclude by saying, sir, that Jersey has a large number of small employers who don't like interference and know how to look after their staff. This is not an area of large industrial employment, so why are we getting involved at all? But if we are, let's be realistic and support this amendment. Thank you, sir.
Thank you, Conor. Does any other member speak on the amendment? Yes, Deputy Hegarau.
Thank you, sir. Yes, I see where the Minister from Social Security comes from in relation to and says that we should have done more work on it, sir. But the point is that as far as we were concerned, the forum had been asked in relation to a 20-minute break. They did all their research and then they came back with a recommendation. The questions obviously weren't about the 15 minutes because they were looking or had been asked by the Minister for the 20 minutes. We simply feel, and I'm grateful actually for the Constable of St Brolade's, because we simply felt that 20 minutes is more realistic than 15. Because, as the Constable from St Brolade's says, is that to move away from wherever you're working, to get your fresh air, to make a cup of tea or have something to eat, it is actually quite difficult to achieve that in 15 minutes. We're quite fortunate in this chamber that we come and go as we need, and we observed yesterday, sir, that actually you were unfortunate that you are not like the rest of us in here, that you can come and go as you please. But it is important that we look after our workers, and particularly at the moment we are struggling to get staff in retail, agriculture, hospitality, etc., etc. And if, as somebody said this morning, UK firms already get 20 minutes. So if I was an employee looking for a job, I'd think, well, actually, that 20 minutes looks more enticing to me than the 15 minutes do. So I think really we do need to bring ourselves up to the 21st century. It is disappointing, as we said, and I think the Minister acknowledged this as well, is that when you look at the leave entitlement, none of us realised it was only 2 weeks, because most of us are very lucky to have had over our working lives significantly more than that. So I think we just need to maybe consider how we would feel if we were being offered 15 or 20 minutes. And sir, I know which one I would take. It is the same as if I was offered 2 weeks, 3 or 4, I know which I would take. And I just think we need to actually start considering our employees a little bit more, sir, and I'm sure most employers will do the same. Thank you, sir.
Thank you, Deputy. Does any other member wish to speak on the amendment? Deputy Ward.
Thank you, sir. Just very briefly, I want to agree with what was just said. I think we're talking about 5 minutes, and let's just uncover some of these straw man arguments again. This is about paid or unpaid leave, depending on the contract that you have of either 15 or 20 minutes. Personally, I think all breaks should be paid because that gives it's unrealistic otherwise. And to be quite frank, I think most employers do that because they realise, as was suggested by the Constable of St Brolade's, you want to keep your staff. If you look after your staff, you may well keep them. And we have a retention crisis on this island, so of attracting and retaining staff as well. The other point to be made is that we're talking about minimum standards here. We're talking about 5 minutes on minimum standards. If a business is seriously going to say, if you add 5 minutes, I won't pay you for all 20 of those minutes, so what type of business is that? I simply don't believe that's a valid argument. And if it is, that's not an employer that's effectively going to look after its staff. And that's when we as an assembly need to step in and say, you need to look after your staff because they are members of our society here and we represent that society. So, sir, this is 5 minutes, members, 5 minutes extra so that you might be able to digest your sandwich a little when you have a break. Really, I think if there is a no-brainer, so this is it. Thank you, sir.
Thank you, Deputy. Deputy St Peter.
Thank you, sir. I'm somewhat confused by this because we know in the island at the moment we have a challenge in the recruitment and retention of staff across the piece, not only those that will be looking at this 5 minutes, but those in other forms of employment as well. And we know the onus on that and to maintain those businesses is the business people, the owners, the employers. And it's up to them really on how they want to look after their staff to ensure that they retain them, maintain their loyalty and maintain their productivity. I don't see where 5 minutes here or there is making any difference. I can't believe that those employees are going to worry if somebody comes back a couple of minutes late because they haven't finished their sandwich or the kettle didn't boil quickly enough. So I'm very confused as what I want to do. I don't want to vote against the Social Security Minister, but there again, I don't want to say that I'm working or supporting an environment where there isn't a degree of flexibility between the employer and the employee relationship for the positive outcome. So I'm probably going to toss a coin on this one, which sounds really particularly immature, but I don't really see it as an issue if we're living in a world where employers are looking after their staff and want the best for their businesses and the service that those businesses provide to the island. So a bit of a weak, wobbly one, that one.
Thank you, Deputy. Yes, Deputy Young.
Sir, I was going to speak, but I don't want to vote against the Social Security Minister because she's so hard-working and sincere, and everything she says is true. But if it boils down to the argument that there's a risk that some employers will behave ridiculously by withdrawing what is already a 15-minute paid break and substitute a 20-minute unpaid one, you know, is that how things really are on this island? I would just think, you know, to me, 20 minutes break seems straightforward. And is it real world that the fear that unreasonable employees are going to abuse this if we go with what seems to be a sensible thing? So I'm really torn. I think I follow very much Deputy Hewlin in this. I don't want to vote against the Social Security Minister. I really respect everything her and her team does. And I see the problem that when you have a forum, you know, you have to listen to them. But I think there's almost a spectrum of something, a fear that I really have trouble in buying into that, sir, about this question that employers are going to pull the plug. Even now, are we really forced to vote? I asked the Minister, are we really forced to do that?
Thank you, Deputy. If no other member wishes to speak, then...
Yes, sir.
Oh, yes, Chief Minister.
Apologies, sir. I think I have to endorse the comments by Deputy Youngson saying that Deputy Martin is one of the, in my view, certainly longer serving, an exceptionally hard-working member of the Assembly. And we see that as a Minister, sir, as well. And I think there's one clarification, not being as close to this subject as perhaps I should have been on the basis I think fishing has been dominating our thoughts for quite a considerable amount of time. But one is which the members may have not understood is obviously whether it's 15 or 20 minutes, it obviously is in addition to lunch breaks. And so it is not just that you get in your entire period. So I'm not too sure about the analogies about that's just time to eat your bacon roll or whatever it is are quite accurate. On the basis, I'm happy to be corrected, but that's my understanding, sir. And I think, therefore, ultimately, the principle is we do have an employment forum. That is their recommendation. Yes, it is, quote unquote, only 5 minutes. But if there are unintended consequences, which is what the Social Security Minister or the rapporteur, I think, is certainly, the proposal of the proposition referred to, i.e. that if we go with the amendment we're debating, that potentially could leave certain employees worse off or having to work the extra 20 minutes and all that goes with it, and bear in mind also that's 20 minutes every working day. It may be that's that is the view of the forum, and obviously, as the Minister has already said, the forum is made up of a wide range of representation, both employee as well as employer. And so it's really whether members wish to go with that recommendation or come up with something else, which is does not seem to be what I call Jersey specific and in the context of Jersey. But I think the principles are we do have a forum. We've got their advice, which is the 15, which is what the Social Security Minister, I think, rightly is going with. And it is an improvement, let's be very clear. And I hope that is welcomed. Versus, and remembering or reminding members that lunch break is an additional to this, that's my understanding. And that we are also informed that there could be unintended consequences if we go with this amendment. And on that basis, certainly I will not be supporting the amendment. It is reluctantly, I have to say, but if there are unintended consequences that come as a result, then I go with the advice that we get. And I really suggest that might be the best way forward for
for other members, but obviously we'll see how the vote goes. Thank you, sir.
Thank you. Deputy Wickenden.
Thank you, sir. I don't know why anyone would be doing this job on the Employment Forum at the moment anymore. Anytime they come to us with a recommendation where they've gone out and they've spoken to businesses, they've spoken to employees, they've gone and done a piece of work, they bring a recommendation, it comes through the Social Security Department to this Assembly, and almost every time somebody goes, I just want a bit more, or I want to change it. It's almost every single time that they go out and do all the hard work and say, this is what the evidence that we've received from Jersey people, from employees as well as employers, to say what they can do. And then every single time somebody goes, well, you know, you've said £2, I'm going to say £3. Said 15 minutes, I'm going to say 20 minutes. You said 20 minutes, I'm going to say 25. Why would anyone bother being part of that employment forum when actually we don't listen to their recommendations and all the work that they do anyway? I know it's just 5 minutes here, but they have consulted on this. They weren't silent on it, and they have turned round and asked the questions. And what came back was 15 minutes is the right level for what the island thinks that's the right level from the consultation they've done, not from other jurisdictions, but from the people here, the people that live in this island, sir. So I'm not going to support the amendment. I'm going to stick with the hard work and show some gratitude to the work of the Employment Forum and thank them for what they do, sir.
Thank you, Deputy. Deputy Pinnell.
Thank you, sir. I completely endorse what the Deputy Wickenden has just said. Having worked with the Employment Forum for 6.5 years, they do work exceptionally hard. They consult very broadly and come up with recommendations, and it would be, in my view, totally wrong to ignore their recommendations. Thank you.
Thank you. No other member wishes to speak. I invite Deputy Pamplin to reply.
Thank you, sir. And again, thank all members for joining in this important debate, which does thankfully mean we're debating islanders' lives. The overall summary, instead of going through each speech individually, the main arguments against seem to be along the lines of the research that the scrutiny did in bringing this amendment. I would just state that our research is and our work in bringing this amendment is actually based also on the Employment Forum's findings. And in the Employment Forum findings, they do mention other jurisdictions. They do mention the Isle of Man. They do mention the United Kingdom. We did have a consultation with the department, the minister, and the Employment Forum themselves, and it was very, very good and helpful to us. There was a commonality that we, on both sides, may have misread and misinterpreted things, and we both agreed that point. But we said there was enough inside what we had seen in the Employment Forum's recommendations, based again the benchmarking that we did in the short time period, that it was acceptable for this Assembly to have a debate, because after all, that's not what we're here to do. Isn't that what we're here for? If scrutiny does find something in a piece of work, but it's to bring it to members to make their decision. That's all we're here to do today. I don't want to get dragged in again to all this political posturing that's going on about things. It's not who I am as a States member. It's not what I signed up to, and I just won't get dragged down to that level of argument, because I just think it's unfair. And again, we're hearing things like, oh, because a body, why would anybody want to work at a body of forum if we don't agree with them? But again, I have the utmost respect, and I've enjoyed the last 3.5 years having consultation and working with Employment Forum. They do a great job, and I think it's brilliant that members of our society come forward and take part in the Employment Forum, in the Citizens' Assembly for Climate Change, in the Jury for Assisted Dying. It's brilliant. But all it is a certain base of work to inform our decision-making. This Assembly is where we debate and bring all debates, all arguments, all research for us to make the decisions. Because if we don't, then anybody could recommend something to minister. I'll be told to do this, so everybody should we just do this, rubber stamp it? What's the point of the Assembly? We're here to debate. That's what we're doing. That's what the purpose is. I don't want to get dragged again into this, maybe because it's my first experience of building to election. That's not what this proposition, it was brought in good faith based on what we read and what we discussed with the Minister. We have discussed also with other people. It's up for members' conscience and their decision making and what they want to do. But I will draw attention back into what we put into the comments paper, which I'm sure everybody has read, where the question was put to the people that they consulted, which I must add, it was presented to the Minister in March of this year, based on all the work, as the Minister did say, which was delayed last year. But again, this year, in the fast-moving pace that has been the pandemic and the impacts that we're only now starting to see with the impacts of the pandemic and the slow impacts of Brexit and other issues around us at the moment with what's happening with the French fisheries dispute, that these things are starting to have an effect on everybody. So yes, this is a really good piece of work, the Employment Forum, and we all thank them for it. But in the last few months, things have changed. And as we're seeing with raising inflation, the rising prices of cost of fuel, and the concerns for holding a job for next year, I just think we need to keep that in mind for the moment we're debating it, which is today. But I draw back to the comments paper I was going to say, where the question that was put forward, if the employment law is amended to require a 20-minute unpaid rest break during the working day, should it imply where an employer's worked for 6 hours or more a day, and the response had 60.4%. Neither a 20-minute rest break should be not induced, only received a 25.41% response. So basically what everybody has kind of been loosely saying, my colleagues have left, about good employees who would support their staff with a roughly 20-minute break if they were late. It's great. We'd expect nothing more of the Jersey employees of this island. And as the Constable Sabrell had highlighted as well in his speech. So all we're saying is, if you've read our comments paper, we just simply say we think there's enough for this debate today, that this will not have the unintended consequences that we have heard. And equally, as Deputy Young was posturing earlier about the impacts of businesses, I have every faith in the businesses of this island to employ islanders, from small businesses to big businesses. They put their well-being of their staff first. And I don't believe if this amendment came in on 1st of January, that the great employees of this island, from small businesses to big businesses would suddenly get rid of their staff or cause problems, when everybody needs staff, when this island needs to pull together. And for all those people who went above and beyond during the pandemic, from the shops to the nurses to people who work in offices around the island, all we're saying is this can be achieved. It's not going to have those consequences. This is a minimum as well. This is a minimum for our island to bring us in line with Gibraltar, Bermuda, Isle of Man, Ireland, United Kingdom, and other parts of the world. This is an amendment from a scrutiny panel who saw that in the research that was provided to us and the discussions we had with the department. Whether you agree or not with us, I won't take it to heart. But don't question our integrity, don't question the work that we've done, and don't question the island who is looking to us to do something today. I propose the amendment. Thank you.
Thank you.
Can I see a speaker for a point of clarification, sir?
Yes.
No, sir, I think we should move to the vote.
That's not accepted. So the appel has been called for. I invite members to return to their seats, and I ask the greffier to open the voting and to place a link in the chat. Of sufficient people voted on the link. If all members have the opportunity of casting their votes, I ask the greffier to close the voting. sure that's the correct number. It's a close vote, but we'll need to confirm this when the names are read out. But the amendment appears to have been adopted, 22 votes pour and 20 votes contre. You'll have them all. I think that's what Deputy Taylor's asked for.
Those voting pour in the chamber, Senator Moore and Mesick, the Conotabs of St Lawrence, St Brallard, Trinity, St Mary and St Martin, Deputy Southern, Higgins, Deputy of St Martin, Deputies Young, Morell, the Hegarah, Ayer, Ward, Pamplin and Gardner. And those voting for in the link, Deputy Alves, Senator Valois, Deputy Tadier, Deputy Truscott, the Deputy of St John, and did we have some? All right, oh, in the conch, right. Those voting conch in the chamber, we have Senator Farnham, the Conotabs of St Helier, Grouville and St Juan, Deputies Martin, Deputy of Grouville, Deputy Lewis, Pinnell, Deputy of St Juan, Deputies Labby, Wickenden and St Mary, Deputy Ash, Gida, Deputy of St Peter and the Deputy of Trinity, and voting conch in the link, Senator Lafondre and the Conotab of St Peter, Deputy Masson and the Conotab of St Saviour.
So if I may, can I thank members in support of our amendment, but can I pay tribute to our two scrutiny officers who are going above and beyond limited resources to help us with our work, and our fellow PEM members. Thank you.
Thank you. We now...
Sir, if I could just say that unfortunately I had a ring binder moment there, and my computer has a social conscience more than I do, and it actually managed to press the pour button after I pressed conch initially.
Right. Well, there we are. We now return to Regulation 2 as amended. Does anyone wish to speak on Regulation 2? In that case, I close the debate on Regulation 2. The members wish to adopt Regulation 2 as amended on a standing vote, in which case, those in favour, please stand.
Appel, please.
Oh, the appel is being called for by Senator Farnham. The appel is being called for on Regulation 2 as amended. And I invite the greffier to open the voting in the chamber and on the link. If all members have had the opportunity of casting their votes. Then I ask the greffier to close the voting. And the Regulation 2 has been amended. 39 votes pour, no votes contra, and 1 abstention.
We had the abstention, please, sir.
The abstention was Deputy Masson. Minister, do you wish to propose regulations 3 and 4 together?
Yes, sir.
Are they seconded? Yes. Thank you. Does anyone wish to speak on regulations 3 and 4? No. Are members content to adopt regulations 3 and 4 on a standing vote? I invite members to show.
The appel, please, sir. On
The
3
appel is
particularly.
being called for. And I invite the greffier to open the voting. Yes, we'll need more time to arrange the link. Invite members to return to their seats. And in a moment, the greffier will, when she's ready, open the voting in the chamber and on the link. The voting is now open. I invite members to cast their votes. Right, the greffier to close the voting.
I appear not to have a vote, sir.
Greffier?
I,
That can't be correct. You must mean 35, do you?
Yes, sorry.
it's
Yes.
flushing.
And Senator Bellegarde put her vote in on the chat just after we closed it. So I don't know if you want to add that. And it was that Paul as well.
I'll add that one as well. All right? I'll add that one in. Yes. I can announce that the regulations 3 or 4 have been adopted. Members, 36 votes pour and 1 vote contra.
We have the 1, please, sir.
The Connétable of St Brelard voted contra.
Minister, do you wish to propose the regulations in third reading?
Yes, sir. I'd like to propose the regulation of the third reading, and I'd also like to thank all my officers who support me and absolutely support the employment forum. Yeah, some days, obviously, they go out and do their work, and it translates differently here. I fully understand what Deputy Pamplin says. We have the last say. At the end of the day, you know, it'll be for them to decide whether it's worth carrying on, really, I suppose. Thank you.
Thank you.
Seconded, sir.
Are they seconded? Thank you very much, Deputy Masson. Does any member wish to speak in third reading? No. Accordingly, I close the...
Aye.
Oh, Deputy Tallier,
Aye.
yes? Yes, you may speak.
Yeah, thanks, sir. I did want to address this issue that's been raised about, the employment forum must feel undervalued.
I'll just
I think
remind you
simply-
that the debate in third reading shall be confined to the content of the draft as adopted in second reading, Standing Order 75.
Thanks, sir. So of course, the reason that the content of the second reading is as it is because we've taken into account what the Employment Forum have said, and we've seen fit to amend a certain part of that. And we've done that not because we don't think there's any value in having the Employment Forum, but simply to say that it is possible for two different bodies to look at the evidence and come to different conclusions. And that's because at the end of the day, we are the politicians who have been elected to make judgment calls and political judgment calls. And we do that weighing up a variety of factors, including our own personal consciences, and sometimes we also use pieces of office equipment to make that decision for us when our consciences fail. I did think it was particularly revelatory that we've seen a stance on the content of the second readings, where the Schrodinger's party, the Alliance Party, if we can call them that, at least were very well disciplined and following their party whip. But it was quite interesting to hear what I thought was a very good joke from the Constable of Trinity, saying that his ringbinder has more of a social conscience than he does, because of course that's what you get if you vote for the Alliance Party. You get a party where inanimate pieces of office equipment have a better social conscience. And the point is, if you want well-drafted second readings, you need to vote for progressive politicians to get that. So I think I'll leave the comments there, sir, because I can see your facial expression. And I'm not sure if that's directed at me, but I think it is at least tenuously all linked to what should be contained in the third reading, sir. Thank you.
Thank you. Conitard of St Saviour, do you want to make a contribution?
No, sir, I do not want to make a contribution because I'm not looking to be elected next year.
Thank you. Senator Farnham.
Thank you, sir. Very quickly, I just want to say I was pleased to support this in the third reading. I'm pleased to support the proposition as amended, sir. We had a lengthy debate over whether 5 minutes was a long time or not, sir, and whilst it might not be in the terms of a tea break, sir, it certainly is sometimes when listening to speeches in this assembly. Thank you.
Senator. I call upon the Minister to reply.
No, as Senator Farnham said, we had a good debate. At the end of the day, the Assembly thought the 20 minutes was better than the 15. We will see. Let's hope there is not too much disruption for companies and workers don't lose any money. We'll know from the 1st of January. Thank you, sir.
Is the appel called for? Yes, the appel has been called for. I invite members to cast their votes in the chamber and on the link. Graphios, open the voting. Four members have had the opportunity of casting their votes, then ask the greffier to close the voting. And I can announce that the regulations have been adopted in third reading, 39 votes for, 1 vote contra.
The Conitard of St Brelard voted contra.
The final item of public business is the World Trade Organization's Privileges and Immunities Jersey Regulations, lodged by the Minister for External Relations and Financial Services. For the purpose of this debate, the main responder is the Chair of the Economic and International Affairs Scrutiny Panel, and I invite the greffier to read the citation.
Draft World Trade Organization Privileges and Immunities Jersey Regulations 2000. The states make these regulations under Article 12 of the Privileges and Immunities Diplomatic, Consular, etc. Jersey Law 1998.
Assistant Chief Minister.
Yes, thank you, sir. As I'm sure is apparent, the External Relations Minister is not with us today, so it falls to me to present this. Sir, as members will recall, on the 1st of January 2021, the UK's membership of the World Trade Organization was extended to Jersey, meeting a long-term international trade objective for the island. In order to meet the obligations of WTO, which is obviously shortened for World Trade Organization, Jersey needs to provide WTO diplomats with certain immunities and privileges, as required by the Marrakesh Agreement establishing the World Trade Organization. Indeed, all WTO members have legislation in place which provides for these privileges. And it should be noted that Guernsey, and probably members may not think that's any recommendation at all, has also recently put in place similar legislative provisions. The draft regulations, if adopted, would therefore codify Jersey's commitment to do the same. Draft regulations presented today are implementing legislation to fulfil Jersey's existing international obligations. The regulations are made under the Privileges and Immunities Diplomatic Consular Jersey Law 1998. Indeed, the draft regulations provide under Jersey law something similar in effect to the UK's number 266, the WTO Immunities and Privileges Order 1995, which grants WTO diplomats identical immunities and privileges. The regulations, if adopted, will give the WTO legal capacity of a body corporate under Jersey law and will provide privileges and immunities to the WTO itself and for WTO representatives, high officers and officials. For the organisation, the regulations provide exemption or relief from taxes, rates and customer duties, immunities from suit and legal processes, and exemption from prohibitions and restrictions on the import and exportation of goods. These are standard and normal arrangements for international bodies. For the representatives of the WTO, the regulations provide immunity from suit and legal process, exemption in respect of personal baggage, and relief from taxes and rates with exceptions. The regulations do not confer any privilege or immunity on a representative or official who is a representative of Jersey, the United Kingdom, or a British citizen. In respect of the high officers of the WTO, namely the Director General and their deputies, the privileges include those given to representatives in addition to relief from parish rates, exemption from taxes on the importation of personal effects, and the refund of customs duty paid on any hydrocarbon oils. A high officer who is a British citizen or resident of Jersey or the United Kingdom may enjoy these privileges and immunities, but only in respect of official acts performed as part of their functions. It should be noted that these restrictions to immunities for Jersey residents and British citizens, restrictions to the immunities of Jersey residents are suitable and internationally recognised and reflected in each of the WTO member countries for their respective citizens. The regulations then set out privileges and immunities for other officials of the organisation, apart from those recruited locally and paid hourly, including exemption from income tax, customs duties and excise duties. The privileges and immunities for other officials only apply to the extent that they have not been waived by the member states that person represents. So the extension of WTO membership was a political decision and one which we closely liaised with scrutiny in regard to timings, agreements, negotiations, exemptions and the mechanisms to facilitate this extension. Bringing into force any new legislation, in this case through regulation, is a matter which should be considered and debated by the states as we are doing so today. As members would expect, we have worked closely with the Law Officers Department to ensure that these regulations reflect precisely the obligations required by WTO membership, and have similarly consulted policy officers across government who may be affected within their respective policy and enforcement portfolios. So it is never easy or especially desirable to present regulations with which we as a bailiwick have little objective other than to comply, although the prize is of course membership of the WTO. So membership of the WTO ensures that Jersey Company have access to global rules on trade in services, goods and intellectual property with other WTO members, including EU member states and the majority of countries worldwide. There is no direct impact on Jersey's economy as a result of bringing into force these privileges and immunities. Finally, it's important to remember that diplomatic immunity is not meant to shield people from criminal or negligent activity. It's supposed to protect diplomats from hostile foreign government. It's extremely unlikely that such a regrettable situation would occur. However, in such a rare event, Jersey will work closely with the UK government in our response and review the privileges and immunities granted in line with Jersey's own offer. We can amend these regulations by further regulation under Article 12 of the Jersey Privileges and Immunities Law. In the regulations themselves, and in accordance with WTO powers and privileges, immunities may also be waived by the WTO itself. It means that, for instance, whether a serious crime has been committed, the WTO could waive the privilege, and that would mean the person involved is tried in local or foreign courts, as the case may be. However, we need to remember that these provisions are only for the fulfilment of international requirements, so any amendments would need to be considered very carefully and obviously assessed case by case. So I ask many members to continue to support our international objectives and obligations and ensure that we can continue to grow our international personality and maintain our status as a responsible and credible global partner. So I move the principles.
Thank you. Are the principles seconded?
Yes, sir.
Thank you. Does any member wish to speak on the principles? Deputy Ward.
Thank you, sir. I just have some questions from what was said there. This does appear to be and these are genuine questions, and I'll try and word them carefully. This does seem to be to produce a diplomatic immunity for those officials of the World Trade Organization that will be necessary, it appears, if we are to become part of that in order to negotiate or be part of those trade negotiations that the UK will take on following Brexit. So there's a link to these things. But what I would like to know is, and I think that what we have to do in this assembly is to look at some worst case scenarios so that we understand what we're voting for and perhaps given permissions for. If one of the people who has this immunity commits a crime in Jersey, a serious crime, we can all imagine what type of serious crime that might be, and we all think about some of the situations in the UK with driving on the wrong side of the road and creating an accident, perhaps. I'm just trying to think of some scenarios. I'd like to ask the Assistant Minister, what would that mean here? Because what we've had is the WTO could remove this immunity. We could go to the UK and ask for that diplomatic type immunity to be removed. But we need to know what we're signing up for here in terms of the way people can come to the island and behave and perhaps be immune to prosecution, because I don't see why those two things have to be linked to be part of a world trade deal. And there is something within my conscience that says, I'm afraid I can't vote for that, because I don't see it as necessary. So those are my questions. I'm absolutely convinced there'll be more if other people speak, but that's it for now, so thank you.
Thank you. Deputy St Mary.
Thanks, sir. Simply to recall that the Economic and International Affairs Security Panel did have a presentation on this matter. We understand the rationale behind it and are supportive of it. Thanks, sir.
Thank you. Conatable St Brelard.
Thank you, sir. This does concern me in the same way as Deputy Ward. I'd like to know from the rapporteur actually what the benefit to the island of membership of the WTO is, and to understand why any of its members or those involved actually should have the sort of immunities suggested, such as not paying rates. Now that is a pretty exceptional thing to do, and I can't see the justification for that in the papers as presented. I think it involves great risk. We are not used to this sort of thing, and I'd be interested to hear the answers. Thank you, sir.
This is Deputy Young.
Thank you, sir. I'd like to ask the rapporteur about the likely practicalities of this in terms of a local organisation. Obviously, the exemptions, as the previous speaker said, are very, very wide. Looking at this, it does look as if it also exempts from income tax and so on, in terms of employees and persons of an organisation. And it also says that these privileges will be eligible, unless I've misread the report, a person who is a British citizen or a resident of Jersey. So therefore, does that mean, for example, that if there has to be an office set up in Jersey in order to facilitate this new post-Brexit world, is that we need to provide exemption from income tax rates all those things. Is that a practical possibility? Because I'll be honest with you, that I'm quite concerned about that. So I'd like to hear more. Is it intended that there will be an office here? Does it need to be an office here? Is it intended that that will be staffed by local persons or persons that are, as a part-time role that are already here? Will these exemptions be enjoyed for those people? And so on. I think I would like to know a little bit more about what we would end up with here. Thank you, sir.
Thank you, Deputy. Conataba St Lawrence.
Thank you, sir. And following on from Deputy Young, my concern too is that should an office be set up over here under Article 4, they would receive relief from rates. And under Article 5 and 6, we see that members and high officers will also be liable to not pay rates should they should this be passed. And I would like the rapporteur to explain why rates should be exempt from payment by these individuals and this organisation. So I can't think of any others who are exempt from paying rates. Thank you, sir.
Thank you. Does any other member wish to speak on the principles? Deputy Morell.
Thank you, sir. And whilst I've got no intention of standing in the way of the regulations at all, I just want to kind of cast members' minds back to when we first debated this a few months ago, and just say this is a new kind of a new direction for the island, being covered by the WTO. We still, and I hope the rapporteur can confirm that this is the case. We don't know if it is in our interests or not, if it will be in the long term in our interests or not to remain party to the WTO. We've done it effectively because of Brexit. It's yet again one of those things that came up, and it may be advantageous. But I'd like confirmation from the Assistant Chief Minister that he is maintaining a watching brief on the effects on Jersey, because if we were to find that it is against our interests, we at some point in the future would need to acknowledge that and withdraw from it. I totally understand that these regulations would need to be passed to facilitate that membership. There are things, I am a fan of the rules-based international order. I think that's ultimately how, as a world, we work together and slowly bring a more peaceful society around the world. But at the same time, as a tiny island, we can have changes forced upon us and be forced to accept, for instance, goods that we don't want to accept into the island through organisations such as the WTO. The WTO is also an organisation that in itself is trying to find its place in the world. There are lots of pressures on the WTO, some of them reasonable, some of them unreasonable. But we also have to be aware that the WTO in 10 years' time may have changed dramatically or may even have ceased to exist, depending how things go. So I just want that confirmation, really, that the department isn't taking it for granted that this is the right thing and is constantly looking to see, or will be constantly looking to see, whether our membership of the WTO is to Jersey's advantage or not. Thank you, sir.
Thank you. Does any other member wish to speak on the principles?
So may I ask the AG a question in due course, please?
Yes, you may. Do you want to ask it now?
Thank you, sir. So referring to Article 4D, which speaks to the privileges and immunities of the organisation itself rather than the officers, so that's 4D. Reference is made there to the relief from rates, as in accordance with Article 23 of the 1961 Convention articles. My question, sir, is does the 1961 Convention articles take precedence over the Rates Jersey 2005 law? Thank you, sir.
Tony?
The answer to that is no, it doesn't, unless this Assembly decides that it should. And the purpose of these regulations is to confer on the organisation immunity from rates. I haven't looked at Article 23 of the 1961 Convention, but I would guess that it would say that there is an obligation to confer immunity from local taxes on the organisation. And by these regulations, the states would be conferring that immunity on the organisation were it to set up an office here.
Thank you. Deputy Higgins.
So I just wanted to say a few words about the World Trade Organization itself. Listening to Deputy Morell, we think it was a new body. It's been around for quite some time. And its basic job is to facilitate world trade and to reduce disputes. It's a dispute mechanism. It serves for the benefit of 164 member states. And we either join these bodies, and all these international bodies do tend to have a provision for their members to have certain privileges in the member states and so on. We have the same with the Commonwealth Parliamentary Association, have been trying to get, one of their members was trying to get diplomatic rights for the Secretariat. All I can say on this is we either want to join these bodies and benefit from the advantages of being a member, or we don't. And if we want to join, we don't really have much choice. And what I would say is I don't see that what's being offered here is any more onerous than anywhere else. Thank you, sir.
Thank you, Deputy. No other member wishes to speak on the principles. Then I invite the Assistant Chief Minister to reply.
Thank you, sir. And if I can address Deputy Ward's point first, it's quite clear from the briefings that I had that if a serious criminal offence was committed in Jersey, then the WTO would revoke diplomatic status for that person and they would be brought to justice. And I think in terms of a number of the other points, Deputy Higgins has summed it up perfectly in that we don't actually have a choice with this. We either accept the conditions that are imposed by the WTO or we don't join. I can't see, there is definitely no intention of the WTO to open an office in Jersey, and I think it's very unlikely that we will ever end up with an official in Jersey. We're simply not big enough on the world stage for that to happen. And I can't see that there will be any substantial economic loss to the island in terms of taxation or rates. Even if one official came to the island, we're probably talking £400 or £500 worth of rates on an annual basis, plus whatever income tax they paid. But it is a fact that if you join the WTO, you have to accept the regulations that they impose, and that includes giving certain non-local people immunity from taxation and other impositions. I think Deputy Mull makes a good point in terms of the advantage, but I think Deputy Higgins answered that in saying that obviously the WTO is a World Trade Organization for facilitation of trade, and we do already in some respects take advantage of that in that we have trade with the states which are done under WTO rules. And as I would remind members, when we were debating the TICA, one of the options for that was that we would have to trade with Europe on WTO rules as an alternative which sets out minimum rates of tariffs and taxes. So there is considerable advantage in being a member of this organisation. And of course, Deputy Merrill's right. You know, we do keep these things under review. We don't just blindly accept that we need to be a member of WTO. We've done it because we feel we need to benefit from membership of that organisation, especially as the world seems to be moving in different directions and the independence of Jersey as a jurisdiction is becoming more and more important rather than less important. So membership of these bodies is particularly important, in my view, part of that move, frankly. I think I've sort of covered all the points, and I thank Deputy Higgins for his contribution because he covered a lot of them for me. And on that basis, I'd like to remove the principles.
Yes. Members content to adopt the principles on a standing vote?
We have the appel, please.
The appel has been called for. I invite the greffier to open the voting. She has done so both in the chamber and shortly on the link and in the link. Four members have had the opportunity of casting their votes, and I ask the greffier to close the voting. And the principles have been adopted, 37 votes pour and 1 vote contre.
The Cornetaba of St Brelard voted contre.
Assistant Chief Minister, how do you wish to propose the regulations in second reading?
With the indulgence of the Assembly, so I'd like to take them en bloc.
Are the regulations seconded? Does any member wish... Thank you. Does any member wish to speak on the regulations in second reading? Accordingly, I close the debate in second reading. Is the appel called for? Are members content to adopt the regulations in second reading on a standing vote? Will those in favour please show? Thank you. The regulations are adopted in second reading. Do you wish to propose the matter in third reading?
Yes, please, sir.
Are the regulations seconded in third reading? Thank you. Does any member wish to speak in third reading? Thank you. Yes,
just briefly, sir, whilst I appreciate the principle of the proposition, I think we ought to take care about being sucked into these things and the consequences of them. The Minister mentioned, it was only going to cost 400,000 or 500,000 in lost revenue. Well, that is a significant sum in these straitened times. And it does have an implication on rates in the parishes, probably particularly St Helier. So I feel that consequences need to be considered before bringing these things through, and some clarity over the benefits which may accrue. Thank you, sir.
Thank you. Does any other member wish to speak in third reading? I call upon the Assistant Minister to reply.
Thank you, sir. And I have the greatest respect for my colleague from St Brellard's, but I didn't use a figure of £500, not £500,000. But I accept that whatever figure, there isn't a small or large economic consequence. Membership of these bodies is, as always, but considered carefully by the External Relations Department, and he's quite right, we do keep these things under regular review, and if we felt it was no longer of benefit to the island to belong to this particular organisation, then we would bring a motion to the Assembly to change the position. But at the moment, I don't think that it's our view that that's not likely. And in closing, so I'd just like to thank my scrutiny panel once again for their helpful input, which is, as always, has been very useful in this particular instance. With that, sir, I'd like to ask for the appel.
The appel has been called for. I invite members to return to their seats. And I invite the greffier to open the voting. She has done so both in the chamber and in the link, on the chat in the link. Four members have the opportunity of casting their votes, then I ask the greffier to close the voting. And the regulations have been adopted. Oh, sorry about that. Unanimously in third reading, 34 votes pour and no votes contre. That concludes public business for this meeting, and I invite the Chair of PPC to propose the arrangement of public business for future meetings. Deputy Alves?
Thank you, sir. There have been some changes to the arrangement of public business since the consolidated order paper was published. An additional 3 items have been added to the meeting on the 14th of December. These are the draft financial 2022 budget, Jersey Law 202p100. The draft Social Security Amendment of Law number 16, Jersey Regulations 202p101. And the draft Health Insurance Fund Miscellaneous Provisions Amendment number 3, Jersey Law 202p102. There are a number of items listed for the next meeting on the 23rd of November, including some significant debates. So I would anticipate that the next meeting will be longer than this one as a result. I also believe the Greffier received a question yesterday about whether the meeting in December will start on the Monday afternoon with questions, so that the government plan debate could start straight away on the Tuesday morning. As things currently stand, this hasn't been decided, although I think it would be a good idea, and it is within the Assembly's power to decide this. So if members could let me know if there are any objections to this before the next sitting, we can then make a decision on it. So with that, sir, I propose the arrangement of public business for future meetings.
And your proposal for the 23rd of November, is that in accordance with the order paper? I think
yes, sir.
It is. Thank you. Is that seconded? Any member wish to speak? Thank you. Thank you, Deputy Alves. Before adjourning, I take the opportunity of reminding members that there is a contested election for jurats on Monday morning. There are 2 new jurats to the Royal Court being appointed, and of course all members are members of the Electoral College, and of course invited and entitled, and indeed urged, if your diaries accommodate this, to attend and vote for the new jurats. Thank you. The state's adjourned until Tuesday, the 23rd of November.